Yeah, plus. My lord, regular bail application, my lord.
You have a
NCB.
okay.
My lord, this accused was arrested, my lord, on 25/09/2021, my lord. Almost 4 years, 9.
So, how many witnesses have been examined so far?
My lord, there are 10 witnesses, my lord. Already 5 have been examined, my lord.
5.
And other co-accused already granted bail, my lord. And from this accused, my lord, nothing was recovered, my lord. Subsequent arrest on the statement of the co-accused, my lord. And the person from whom
Okay,
they seized, my lord.
Whether you have submitted the evidence
Evidence I have
of
submitted.
all the witnesses?
Yes, I have submitted, my lord.
So, let us call for a report from the trial court.
Yes, my lord.
Heard Mr. T. Hussain, learned counsel for the petitioner, and Mr.
I Singh, madam.
I.
I Singh.
I Singh, learned standing counsel for the NCB. This application under section 483 of the BNSS 2023 is prepared by the accused for granting him regular bail, who was arrested on 25th of September 2021 in connection with NDPS case number 49 of 2022, which is pending before the Court of Learned Special Judge NDPS, Kamrup M, arising out of NCB PS case number 25 of 2021 under section 8C/21C/29 of the NDPS Act 1985. The learned counsel for the accused submits that altogether 10 witnesses have been cited in the charge sheet. And out of the 10 witnesses, only 5 witnesses have been examined so far. 10 co-accused have also been granted bail by the trial court.
Yes.
By the trial court. And under such circumstances, he submits that the present accused is also entitled to bail, and therefore he has consented to allow the application. In view of the submission of learned counsel for the accused, this court deem it necessary to call for a report from the learned trial court in respect of the present status of trial. List the matter on
July last week. July last week.
And that may be given, my lord.
It was July.
short
27 July.
27.
Milord, we may also be allowed to place objections. Objections.
the learned counsel, standing counsel for the respondent, NCB submits that he may be allowed to file objection petition. Fair allowed. Same order in item number 2 also.
2 is same, my lord. Same accused. Leave leveless, my lord. Leave.
For motion item 3.
Worship, I have instruction not to press this matter. We would not like to press the matter, Your Worship.
Pardon?
Withdraw the matter.
Pardon?
We would like to withdraw the matter, Your Worship, not to press the matter.
Mr. B.J. Mukherjee, learned counsel for the petitioner, submits that he has the instruction to withdraw this matter. Accordingly, this CRPIO number so and so is then disposed of on withdrawal. Liberty?
Your Worship, not
No, not necessary.
much of
Item 4.
Worship, this CRP has been filed against the common judgment and order dated 21/12/24 passed by the learned additional district judge Dibrugarh. But the notices have to be issued.
Third, Miss
P. Agarwala.
Learned Counsel for the petitioner. There's a revision petition. Where is Mr. Gupta?
Well, the common judgment and order is under challenge, my lord. The order, there was an order passed by the state officer by which the illegal occupants were removed from the land. Thereafter, my lord, they challenged that order under section 9 before the Nana district judge, my lord. That order is under challenge, my lord. The judgment, it has disposed by common order, my lord, several misappeals. My lord, that is under challenge, my lord. And the main ground of challenge is that, my lord, the honorable court, the learned court below has not taken into consideration the fact that it is a railway land. Just on the basis that these occupants are residing there for more than 50 years. On that consideration, my lord, the eviction order was interfered with. Now, these are the railway land, my lord. 1950 acquisition has taken place. Acquired land, my lord.
Third, Mr. Gupta, Learned Counsel for the petitioner. This petition under Article 227 of the Constitution of India is directed against the common judgment and order dated 21st of December 2024, passed by the Learned Additional District Judge Dibrugarh in Miss Appeal case number 3267, 2022. It is to be noted here that by the impugned judgment, an order dated 21st of December 2024, the Learned Appellate Court has set aside the order dated 11/3/2022, passed by the state officer Anak Railway Tinsukia under the provision of the Public Premises Eviction of Unauthorized Occupant Act 1971. Peruse the petition and the documents placed on record, and also peruse the impugned judgment and order dated 21st of December 2024. Issue notice to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the Learned Appellate Court. List the matter after 4 weeks.
Hello, bye.
Yes.
Limitation measures. Your lordship, when one judgment.
Yes. Ramnath Sahu.
Yes, that's the question. I think. In fact, does that go against me also?
Pardon?
Does that go against my question? Here in this case also, your lordship is rightly that some liberal approach have been taken. But in this, at the same time, it mentioned that, however, at the same time, court must bear in mind that delay would have caused a valuable right to accrue to other party, and that such rights should not be defeated by conditional delay in a routine manner. They should have been contained in written manner. But what learned trial court has done, that just readily accepted the explanation that he is not aware about the fact of the case. Trial court has readily accepted it without going to the facts of the case. If the trial court would have gone through the facts carefully, trial court would have found that those statements of the petitioner that he was not aware about the case and he came to know about the case only in the year 2018 when his paternal uncle had shared some email with him. That was his case. But prior to that, if the trial court goes through the case, it would have been clear that all these facts are false. Only on the basis of their submission, their petitions, my lord, it can be seen that he has made wrong statements before the court, false statements before the court. So,
And that petition is at page number?
my lord, I am thinking. Their petition, my lord, many irrelevant facts are made in the petition, many irrelevant facts are there, but I only point on only relevant facts. My lord. It is at page number, my lord.
35,
My
Annexure
lord,
2.
no, running page, my lord. It is running page 15. Their petition. Annexure number 1.
What is Annexure 2 then?
My lord.
What is Annexure 2?
Annexure 2. Annexure 2 is, my lord, order 22-4. Annexure 1 is regarding conditional delay or annexure 2
Regarding substitution.
substitution. My lord.
Okay.
My lord. Annexure 1, my lord. In page 17, my lord.
Yes.
Page 17, my lord. Here starts the main rule. The applicant Onisu Roman has gone to Bihar for schooling in the year 1985 when he was in 6th standard, and thereafter he completed his graduation from BITS in New Delhi in 1996-99. Over all the years, the applicant occasionally used to visit his parents in Gauhati and in Bihar, where also the original plaintiff had business autonomous ties. After completion of his studies in 19, started working at Delhi and Bangalore till 2017 and then relocated to Oman, Muscat. Till now, he has been residing outside India on account of service and occasionally visits his mother. So it is not that he is totally cut off. From student's life, he used to study outside Guwahati, but he normally is summer vacation, winter vacation, used to come to Gauhati, used to stay with parents. It is not that he was totally out. Number one reason. And then secondly, my lord, the present applicant had no knowledge of either the pendency or subsequent dismissal and abatement of above mentioned suit until recently, when appointment to tried to throw out his mother, namely appointment to from the suit permission, she had to file a case against him and his wife under Domestic Violence Act. These are false statements. These are statements, my lord. It is during the last week of June, my lord, it is during the last week of June 2018 that applicant had to inquire about the suit premises with his brother of the original plaintiff, namely Akhtar Hussain, who was one of the partners of the plaintiff in partnership firm, namely. So he wants to say that he was not aware about the suit premises, about the property at Dhirenpada, Gauhati, until his mother told him. Then next paragraph will be important paragraph. Otherwise, all these things are. Para 9, page number 9, para 18 and 19. Para 18 and 19, my lord, where he is studying about his knowledge, my lord. 18 and 19. Hello. 18, my lord. that having come to know about series of frauds committed by both party, the applicant also became aware of title suit number 2019, which was filed by late Muhammad Mukhtar from email correspondence with Akhtar Hussain. So according to me, came to know about this case from email correspondence of Akhtar Hussain, who is his uncle, Akhtar Hussain. The applicant also became aware of facts and circumstances under which the same had to be filed by late Muhammad Akhtar from a copy of plaint and some of documents exhibited in title suit which were emailed by Akhtar Hussain to applicant. The applicant begs to the same is following paragraph in the instant petition. So, my lord, Akhtar Hussain was power of attorney of the original plaintiff. Akhtar Hussain is the uncle of plaintiff and defendant, and he was a power of attorney holder.
So Sharma, let notice to what this is.
My lord.
Pardon, Mr. Sharma, learned counsel to the petition. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 13/3/2026, passed by the learned Civil Judge Junior Division number 5, Kamrup M. Gauhati. In Media case number 19 of 2023, arising out of title suit number 15 of 2023. It is to be noted here that by the impugn order dated so and so, the learned trial court has condoned the delay of 5,269 days and setting aside the abatement order dated 20th/12/2004 by imposing a cost of rupees 3,000. Peruse the petition and the grounds mentioned therein, and also peruse the impugn order dated 13/3/2026. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Further, considering the facts and circumstances on the record, the impugn order dated so and so stands state till returnable date. Since this order is being passed ex parte, the other side will be at liberty to file application for petition modification of the same.
Proceeding in title suit.
Registration call for a scanned copy of the record.
And proceeding in title suit may be state. Proceedings in title suit may be state till that.
No, only impugn order is state, not the proceeding.
Item 6.
Do not take.
May please, Your Lordship. Lordship, the petitioner is the decree holder. They have filed one suit for specific performance of contract. Lordship. Kindly see page 24, the order passed in the title suit judgment, Lordship. Notice was issued, defendants appeared and sought for time for filing written statement, but later on they remained absent without any steps, so suit proceeded ex parte, Lordship. Page 24, paragraph 21, Lordship. In the result, the suit of the plaintiffs is decreed ex parte with cost. The plaintiffs are entitled to get the following reliefs in this suit: that the plaintiffs are to deposit tender balance consideration of 20 lakhs only, and the defendants are to execute a registered sale deed in favor of the plaintiffs, who are the legal heirs of the deceased plaintiffs, preferably within 3 months of obtaining necessary sale permission from the competent authority in respect of the suit scheduled land, failing which the plaintiff shall be entitled to execute the decree in accordance with Order 21, Rule 34 of CPC. So there is a direction in favor of the plaintiff to deposit 20 lakhs and in favor of the defendants to obtain sale permission, and after obtaining the sale permission, within 3 months, sale deed has to be executed. If they do not execute the sale deed after obtaining the sale permission, then only the plaintiff can file an execution petition. So, Lordship, the defendants, when delaying the matter in obtaining sale permission, One petition was.
No, why don't you apprise the court then by filing appropriate petition?
Lordship, as the
That the
defendants,
defendant has not been carrying out the order passed in the state
Lordship,
title suit.
as because they are assuring that they are obtaining the NOC from the competent authority, for which some signatures were also taken, and thereafter they remained Lordship absent. Again, Lordship, they've stated that we are going to obtain the NOC as per decree.
Let
They even did
notice
not-
go at this is this.
Lordship, only notice, Lordship. Because they have contested my petition by filing an objection. So, but they did not file any title appeal against this order, Lordship, against the judgment of the trial court, Lordship. That means that, Lordship, they are pursuing the matter for obtaining NOC, but they have, when they delayed the matter, then only this petition was filed by the petitioner. Only they notice, Lordship, at this stage.
If within the period of 3 months, the defendant failed to obtain the sale permission, you could have informed the trial court about the same.
But Lordship, the language itself says that after obtaining NOC, and from the date of NOC, within 3 months, if they fail to execute the sale deed, that direction is on about, Lordship, defendants, not
Yes.
in respect
Or
of
so
the.
to the learned counsel for the petition. Learned senior counsel assisted by Miss Learned counsel for the petitioner. This petition under Article 227, read with section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 28/4/2026 passed by the learned civil judge, senior division number 1, Kasar Silsor, in Meje case number 79 of 2025, passed in title suit number 35 of 2021.
2021.
Noted here that by the impugn order dated so and so, the learned trial court has rejected the petition filed by the petitioner seeking condonation of delay in depositing stroke tendering balance consideration of rupees 20 lakhs. Has been rejected. There is the petition on the grounds mentioned therein, and also there is the impugn order dated 28/4/2026. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. After 4 weeks.
4 weeks, Lordship. A date may be given after 4 weeks. Lordship. In- Obliged, Lordship.
May I please the Lordship? Lordship, we have preferred this civil revision petition against the order dated 23/2026. Lordship may find the present order at page number 64. Lordship, what has happened? The brief matter of the fact is that the petitioner, the present petitioner, has instituted a title suit number 85 of 2014 in the court of the learned district judge under section 13(1)(a) and 13(1)(b) of the Hindu Marriage Act for dissolution of marriage.
Madam, you see,
Lordship.
in Mat Appeal number 23 of 2025,
Yes, Lordship.
no stay was granted by this court.
Yes, Lordship.
Then
Lordship, we have filed an application before. Lordship, what has happened? After the said title suit was dismissed, the present petitioner filed the matrimonial appeal. Lordship. Thereafter, we received a notice that the respondent side has preferred a title suit for restitution of conjugal rights, Your Lordship. Lordship, in that title suit, we have filed an application for stay of the title suit, which was dismissed by the impugned order, Lordship. Lordship. Okay.
If I may, my lord, the appellate court, first appellate court, my lord, rejected the stay, my lord, on the grounds that, my lord, this matter was not a subject matter of that appeal, my lord, because that appeal arose out of title suit number 85 of 2014, which was for divorce, my lord. And now, my lord, there's another matter pending, which is for restitution of conjugal rights. Now, my lord, in that matter, for restitution of conjugal rights, we had filed an application for stay, my lord. Then that was rejected. Now, my lord, it is our apprehension that, my lord, if a judgment is passed in that matter and a judgment in the first appeal is also passed, my lord, it may be contradictory to each other. On that ground, my lord, we had filed an application for stay. My lord, that was rejected. Against that order, we have preferred this instant civil revision.
And what is this that appeal is pending now?
My lord, the appeal is pending, matrimonial. It is for hearing, my lord.
Hearing.
Admission. It is for admission, my lord. Admission hearing, my lord.
It has not yet been admitted.
No, my lord. My lord, at this.
Let notice go.
Yes, my lord.
Heard, Mr.
Ji, imtiaz, my lord.
Learned counsel for the petitioner in this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 28/3/2026 passed by the learned additional district judge Sibsagar in title suit M number 93 of 2015. It is to be noted here that by in order dated so and so, the learned trial court has dismissed the petition filed by the petitioner for staying further proceeding of title suit number 93 of 2015 till disposal of the matter appeal number 23/25 pending before this court. Peruse the petition and the grounds mentioned therein, and also peruse the impugned order dated 28/3/2026. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within with them to the list after 4 weeks. So do we take this matter with the matrimonial appeal?
My lord, that is not necessary, but if my lord deems it fit, it may be tagged. My lord.
Regis shall take this matter along with matter appeal number 23 of 2025 pending before this court and list the same together.
My lord, I prefer an interim, my lord, in this matter. Interim, my lord. Stay. Deeply obliged.
Let the other side appear.
Yes, sir.
Interim pair of the petitioner will be considered on returnable debt.
Number 48.
May it please your lordship. My lord, this revision petition filed under Article 227 is against an order of injunction, ex parte injunction granted by the commercial court. The
Is
Indian,
that order not appealable order?
my lord. My lord, on that, my lord, this query, my lord, I have to satisfy first, my lord. May I take your lordship to, my lord, section 12A of the, my lord, Commercial Courts Act?
No, you first answer my query. Is it not a decree?
My lord. It's not a decree, my lord. Only a appeal will lie against the decree, my lord. If your lordship kindly comes to appeal to the section 8. If your lordship, my lord, comes to section 8 of the my lord, the commercial
Maybe.
courts.
Is it not an appealable order? All right, it is not a decree.
My lord, it's an interlocutory order, my lord. It's an injunction, ex parte order of injunction. And my lord, I will satisfy your lordship, my lord, that my lord, the Article 227 petition will lie, my lord, before your lordship. My lord, may I take your lordship to one judgment, my lord? Because at that point I have to satisfy your lordship first, my lord. In fact, this is a judgment of the Karnataka High Court where, my lord, 8 Supreme Court cases have been discussed. And all those, my lord, have been, my lord, quoted also in the judgment. Kanpur Flower Sardine Private Limited. Now, if your lordship kindly comes to paragraph 12 of the judgment at, my lord, page 7. My lord, I have placed the decision of the High Court because, my lord, the Supreme Court cases have been, my lord, quoted here. Roman 7, analysis and finding. Has your lordship got it, my lord? Scope of interference under Article 227 of the Constitution. Scope and limits of High Court supervisory jurisdiction under Article 227, my lord. I will not trouble your lordship by reading all those, my lord. L. Chandra Kumar, which your lordship knows, my lord, the 7th Judge Constitution Bench, that has been quoted. Then, my lord, Surya B. Rai has been quoted. And that way, my lord, other Supreme Court decisions have been quoted. Then your lordship may kindly come to, my lord, paragraph 21, my lord. That your lordship finds at page 33. Where, my lord, the principles have been summarized.
Okay. Page number?
Page 33.
Development all document আছে।
Page 33, paragraph 21. Has your lordship got it?
Yes.
An examination of the law as set out herein above reflects that, number 1, it is important for the courts to ensure that the power under Article 227 be exercised to ensure compliance with the objectives of the enactment of Commercial Courts Act. This is, my lord, with reference to Commercial Courts Act, my lord, remains intact. Roman 2, the power of superintendents under Article 227 are circumscribed and supervisory jurisdiction is to be exercised sparingly and cannot be used to substitute the judgment of a subordinate court or tribunal to correct the trivial errors. 3 is important, my lord. Article 227 of the Constitution should be used for jurisdictional errors causing grave injustice. The power should be exercised where a party is left remediless. Then, my lord, 4, what has been barred by Section 115 of the CPC through Section 8 of the Commercial Courts Act cannot be subsequently revived by using the power under Article 227. Decrees and judgments are amenable to challenges within the period of limitation as prescribed under Section 13. Then interlocutory orders passed which are amenable to challenge under Order 43 of the CPC and Section 37 of the CC Act may be challenged by an appeal under Section 13. Then interference in petitions arising from commercial courts is limited to only instances where non-correction under Article 227 would lead to manifest injustice. Some circumstances would be when errors A are incapable of correction at the later stage and B give rise to the level of patent perversity or jurisdictional failure. These are the principles, my lord, which has been carved out of the, my lord, Supreme Court decisions. Now I am on, my lord, serial number 3, Roman 3. Article 227 of the Constitution should be used for jurisdictional errors causing grave injustice. Now, my lord, I'll show, my lord, what is the jurisdictional error in, my lord, passing the injunction order. Firstly, my lord, this is regarding, my lord, supply of certain articles. Bitumen and, my lord, HSD that has been supplied by the IOC to the, my lord, plaintiff at Arunachal. Your lordship knows, my lord, in a, my lord, in a contract where the contract is to be performed at a particular place, only the, my lord, courts at that location will have the territorial jurisdiction to entertain the suit. So it is an Arunachal, where the, my lord, the suit ought to have been filed. Secondly, my lord,
Where the IOC office is situated?
my lord,
Where the IOC office is situated?
IOC office is situated, my lord, in Gauhati, everywhere, all over India, my lord.
All over
But
India.
then, my lord, this the contract that, my lord, they have given us to supply. That supply is, my lord, in Arunachal Pradesh for construction work, my lord. Road construction and machineries, the, my lord, bitumen and, my lord, HSD, the IOC was supplying to the plaintiff. And, my lord, after completion of the supply, he was not, my lord, paying the amount, and therefore we wanted to encash the bank guarantees. And he was asking for time and again, for extension of time, and we have been granting time. And he knows his liability, my lord, 2 years back. And then, my lord, showing urgency, he has filed the suit. And second jurisdictional error is that, my lord, the trial court has granted a relief which was not sought for by the, my lord, plaintiff. I'll take your lordship to that, my lord. So, my lord, so far as maintainability of the 227 petition is concerned, my lord, all the cases have been, my lord, discussed and the principles have been summarized. Then your lordship will have to examine, my lord. Your lordship need not go into the facts, my lord. It is basically on law. Now, if your lordship sees the prayer in the, my lord, plaint, my prayer in the injunction petition, that your lordship will find at page 97. That is a copy of the, my lord, application for injunction under Order 39, Rules 1 and 2. Prayer 1, ad interim injunction restraining the OP number 1, that is IOC, their agents, workers, servants, assigners, and anybody working for and on behalf of them from invoking the bank guarantee as detailed in Schedule A. Now, Schedule A, your lordship will kindly peruse. These bank guarantees, my lord, they are expiring soon, my lord. My lord, serial number 1, that will expire in October 2026. All these, my lord, 3 are in October 2026. Now, the order that has been passed, if your lordship sees, my lord, that is at, my lord, it starts at page 100. The operative part is at 116.
Yes.
Paragraph 28. In accordance with the principles of justice and equity, this court finds it imperative to issue an ad interim injunction order under the following terms. 1. An order of ad interim injunction staying on any coercive action by the defendants as may arise in relation to the email dated 18/11/2025. That was not his prayer, my lord. Your lordship has just seen the prayer. Number 2, the defendants OPs are restrained from invoking bank guarantee Schedule A in terms of the impugned email dated 18/11/2025. So, my lord, the trial court, my lord, exercised jurisdiction beyond the prayer, my lord. That is an excess of exercise of jurisdiction.
But the question is whether this petition is maintainable or not. That has to be first ascertained.
My lord, 115 is not maintainable. Section 115 of the CPC, my lord, under that I cannot come, my lord. And therefore, this decision I have placed, my
No,
lord.
that order was passed under Order 39, Rule 1 and 2.
1 and 2, my lord.
You come to this Order 43.
Order 43, Rule 1. But that, my lord, that I can come, but then, my lord, I can also come when my lord, there is jurisdictional error, my lord. I can come under, my lord.
Maybe, but when alternative remedy is available, you cannot.
No, my lord, here is a case, my lord. Your lordship will kindly see the backgrounds a little.
Maybe.
Now, my
That
lord,
can
then
also be
ex parte-
dealt with in the appeal also.
My lord, ex parte order of injunction was passed. We have filed, my lord, our written objection. Then the court said you
No,
file
no.
written statement. We
For
have
ex
filed
parte
written
order,
statement
separate set of rule is not provided.
for, my lord, a commercial courts act. My lord, so far as Assam is concerned, my lord, rules have not been framed.
Then
My lord. Now, my lord, the another ground that I am taking, my lord, why I am before the High Court, my lord, if your lordship kindly takes up the Commercial Courts Act, may I take your lordship's time, my lord? I will not bother much, my lord. Section 12A of the Commercial Courts Act. Because, my lord, this is a special act and, my lord, the provisions are to be strictly adhered to. Now, Section 12A says, my lord, pre-litigation, mediation and settlement. A suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-litigation mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. Now, my lord, these two words are very important, my lord. A suit which does not contemplate an urgent interim relief. Now, this contemplation cannot, my lord, these two words cannot be said, my lord, taken very lightly, my lord. On that, my lord, I'll place a decision of the Honorable Supreme Court. If your lordship kindly takes up. Yes. 2024 5 SCC 815. Yamini Manohar versus TKD Kirthi. Now, my lord, here, if your lordship kindly comes to paragraph 6, 10 and 11, my lord. Small paragraphs. Paragraph 6. The words used in section 12A of the Commercial Courts Act are a suit which does not contemplate any urgent interim relief, wherein the word contemplate connotes to deliberate and consider. Further, the legal position that the plain can be rejected and not entertained reflects application of mind by the court, namely the requirement of urgent interim relief. This requirement has not been fulfilled by the trial court, my lord. It has to, my lord, delve into this question, my lord, whether there was an urgent interim relief required. Now, the claim he has been making, my lord, it is an admitted position. He has admitted in the plain itself that, my lord, so much amount is due. And he has been, my lord, granting, they're taking time, extension, and IOC has been granting extension. And at some point of time, my lord, after 2 years, he comes, my lord, he says that there is urgency. This is one aspect. Then your lordship may kindly come to paragraph 10. This has to be examined, my lord, by the trial court. Cannot just, my lord, like a civil suit, they cannot, my lord, just issue summons and issue injunction. Paragraph 10. We are of the opinion that when a plaint is filed under CC Act with a prayer for an urgent interim relief, the commercial court should examine the nature and subject matter of the suit, the cause of action, and the prayer for interim relief. The prayer for urgent interim relief should not be a disguise or mask to wriggle out of and get over section 12A of the CC Act. Now, your lordship may skip the rest part, but have come to paragraph 11. Having stated so, it is difficult to agree with the proposition that the plaintiff has the absolute choice and right to paralyze section 12A of the CC Act by making a prayer for urgent interim relief. Camouflage and guise to bypass the statutory mandate of pre-litigation mediation should be checked when deception and falsity is apparent and or established. The proposition that the commercial courts do have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiff alone to decide whether to resort to the procedure under section 12A of the CC Act. An absolute and unfettered right approach is not justified if the pre-institution mediation under section 12A of the CC Act is mandatory as held by the court in Patil Automation. Now, my lord, the trial court did not, my lord, delve into it only because it says that there is urgent relief required, the urgent relief was granted, and thereafter, my lord, the injunction hearing does not take place even, my lord, after filing the objection, written statement, and also we filed an application under Order 39 Rule 4 for modification of that order. That is also not heard On the sole ground, the bank was yet to appear. Now, here is a case, my lord, if the matter is delayed, then what happens, my lord, the bank guarantee is lost its force. Therefore, my humble prayer, my lord, at least your lordship will, my lord, extend the bank guarantees, my lord. So that, my lord, the bank guarantees.
No,
do not-
that's all right, but first we have to examine the maintainability of this petition. Because in a recent decision of the Supreme Court, Muhammad Ali versus V. Joya,
My lord.
reported in 2022 Live Law SC, page number 574. It is stated that revision petition under Article 227 would not to be entertained when a statutory alternative remedy by way of appeal is available under the Code of Civil Procedure.
My lord, perhaps that is not with regard to commercial courts. Act.
Maybe,
I'll examine that. My lord.
maybe.
I'll examine that. Or let it come on Monday, my lord. I'll address your lordship again. Huh?
Monday,
Let it be Tuesday, my lord, instead of Monday.
Tuesday, not, Tuesday is hearing day. Let it be on Wednesday. Wednesday. Heard, Sir M.K. Sharma, M.K. Sodore, learned senior counsel assisted by Mr. Borwa, learned counsel for the petitioner. List the matter on Wednesday for hearing on the point of maintainability of this petition under Article 227.
Obliged, sir.
Items for orders, item number 16, order. Lordship, here I pay for a short accommodation, otherwise lordship the process has been done. And Department of Social Education Secretary of processing the matter. But certain clarification further was required from the director, I am told today, lordship. So lordship will post this matter next week, lordship, perhaps something will come up, lordship. Today, I pray for something.
Kindly see the last order now.
Lordship,
Your lordship,
the last order, then director-
permit the time, but kindly see the last order.
Okay, wait for 1 week.
One.
Mr. R. Islam, learned counsel for the petitioner, Mr. P. Sharma, P. N. Sharma, learned counsel for the contender. Mr. Sharma submits that the submits that though he was directed to produce the compliance order before this court, yet the order could not be complied with as some. What is required?
Lordship.
What is required?
Some clarification was sought by the secretary. From
Some clarification is being sought for by the secretary.
order by communication that
By the contender number 2 from the contender number 1. Contender number 1. And accordingly, he pressed for listing the matter in the next week. They are allowed to list the matter on.
on.
Obliged.
17.
By others, Anisla. By others, Anisla, mention person. Lordship, in this matter, the LCR has been received, Lordship, and the service is also completed.
So we will fix the matter for hearing then.
Lordship, it can be fixed for hearing.
Heard Ms. F. Ahmed, learned counsel for the appellant, and Mr.
PHOP.
T.S. Odore, learned counsel for the respondent. It is submitted at the bar that in this appeal, service is completed and the LCR has also been received. And as such, the matter may be listed for hearing. Accordingly, it is provided that this shall list the matter for hearing on fixed date. It is 2016
16
matter.
Lordship.
18 August.
18 August. obliged.
Can it be first week of September?
First week.
I have some personal difficulties.
Okay.
September. 3rd September.
Lordship.
Item 18. No, service is completed.
Service completed.
It's for hearing manual.
LCR receipt.
Receive manual.
Okay. Third, Mr. D.C. Fukon, learned counsel for the appellant, and Mr. Mishra for the respondent.
Number 1.
Respondent number 1. It is submitted at the bar that in this appeal service is completed and the LCR has also been received, and as such, the matter may be listed for hearing. Accordingly, it is provided that the citizen list the matter for hearing on or fixed. It's 18 matter.
18th August. 18 August. 19.
May it please your lordship. Lordship, as per the last judicial order, lordship, first of all, lordship, I beg apology, lordship, last occasion I could not appear, I missed the items. However, lordship, as per the direction given by the honorable court to take steps, I have taken the same. Yesterday, lordship.
When?
On respondent number 5 to 9, yesterday, lordship.
Yesterday. Third, Miss Ida's learned counsel for the appellant, Mr. Bakhtiar for respondent number 124. 124. The learned counsel for the appellant submits that she has taken step upon respondent number 5, 6, 7, 8, and 9 yesterday only. And accordingly, it is provided that list the matter after 4 weeks, awaiting service report upon respondent number 5, 6, 7, 8, and 9. LCR receipt?
Deeply obliged.
Item 20.
May I please your lordship? Lordship, here in this, there are 3 IS, 1185, 1186, and 1187, my lordship. This is a delay, abetment, and substitution. My lordship, respondent number 1, my lordship, my service appearing, and with regard to the other respondent, service is complete other than respondent number 4 and 6. So, after, by the office note, my lordship, on 27/2024, 2024, by the report of the server, we came to know that respondent number 4 and respondent number 6 expired. So we have filed delay, abetment, and substitution with regard to respondent number 4 and 6 that was allowed by the honorable court. We filed amended cost title also. So my lordship, now the notice will be served upon respondent number 4 and 6. With regard to respondent number 1, sir appeared, and with regard to the other respondent, service is complete.
Now there remains to be completed in respect of respondent number 4 and
Notice
6.
will go only with regard to respondent number 4 and 6.
The
Legal
only-
heirs of respondent number 4 and 6, which we have already filed amended cost title, my lordship.
Whether you have taken step.
I have taken step, my lordship. I have taken step, and through that step on 27/2024. My lordship.
No. After the implement of legal heirs of respondent number 4 and 6.
My lordship, it has come today. It has come today after we have filed amended cost title. Now it has come for the first time, my lordship, today. So we initially with regard to their substitution, we have done, they appeared. But with regard to this delay petition, my lordship, the fresh steps will go. Because it is with regard to this delay petition with regard to the substitution of the appellant's legal hire of the second appeal, Suren Gogoi. Suren Gogoi, he expired, my lordship. So this delay petition was with regard to the substitution of his legal hires. And during serving of notice, we came to know about the death of respondent number 4 and 6.
When did you file the amended cost title?
My lordship,
When did you file the amended cost title?
My lordship, lordship date, actually, it was reflect, my lord, in second appeal, it was shown in the main. I have just seen the date. In this main second appeal, my lordship. There it is reflecting, my lordship. We have submitted and it's reflecting, my lordship. My lordship, with regard to this delay, my lordship, I have informed my junior, with regard to this delay petition, we have submitted amended cost
What is
title. with
the-
this- Yes, my lordship, with the main appeal, but with regard to this also, we have to file amended cost title with this delay.
Now you tell me, IN number 1185 of
My-
2024.
My lordship,
This application is for
delay, with regard to delay for setting, delay of my lordship,
Mr. Jain, you have any objection in condonation of the delay?
Affidavit in opposition already filed.
You have filed.
There is a actual delay of not 1400 some days.
870.
875 days.
Yes, 875 they have written, but it actually they have deducted some period, actually 1400 days. In my affidavit, it is there.
No, maybe, but the registry has calculated it as 1875.
That's what I mean, not 875. They are saying 875, but it is.
So what is the ground?
My lordship, here what happened was that, my lordship, the ground is at, my lordship, Suren Gogoi, my lordship, my lordship would be pleased to peruse page number 14 for a second, my lordship. This, my lordship, this Suren Gogoi, he married for 3 times, my lordship. And this Suren Gogoi, he married 3 of elder, youngest, 3 own sisters. So what happened after the expiry of the first sister, he married second sister and thereafter the third sister. So while during the period of Suren Gogoi, he was the person who used to regularly, with regard to, was in contact with the advocate. So he was continuing the proceedings. After his death, my lordship, on 30/8/2019, the engaged counsel was not aware with regard to the death of Suren Gogoi. And thereafter, the engaged counsel contact one of the neighbor of Suren Gogoi, and thereafter came to know that he expired. And thereafter, these legal hires contact the advocate and they want to be party to the proceeding, my lordship.
In which paragraph of your
My lordship, I
application?
have
you have-
written everything clearly in paragraph number, my lordship, in 3. 2 and 3, my lordship.
Yes, Mr. Zain, where is your objection petition?
I filed on 12/2/2025. 1185.
Technically, 1185. In fact, 24 खाली है. Check करो. Asset. I wanna. February. 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 So you can take over in. Now go. So possibly by videos of this condition. Not to my.
It is not available on the record.
My lordship.
The order 15/5/2024. Order 6. Maybe is
In which case? I 1185.
in IA 1185.
Order date 4/6.
No, 15/5. No, it's 15/5 years.
পকে সামলে করলে দেখাই দিলে
No, on
File
that
on-
day, you only informed the court that you would like to file objection.
Lordship, it was filed on 12 February 2025.
12 February.
February 2025, because I have received on that day.
But it has not been tagged with the record. Let it be on Wednesday,
My
next
lordship.
Wednesday.
My lordship.
Heard Ms. Borua, learned counsel for the applicant, Mr. Zain for the respondent, opposite party. Mr. Zain, during the course of hearing, submits that he has filed objection in this interlocutory application on, who is that?
12 February 2025.
12th of February 2025, but having gone through the record, the objection is found to be not available. And in that way of the matter, it is provided that recessal lays the matter on Wednesday, taking the affidavit, taking the objection petition filed by Mr. Zain. Please take it.
My learned had submitted that two of the LR are still to be. Not,
Pardon?
two of the LR not given notice till now. As per the counsel of the appellant, it is. They have not given notice to two of the LR. As per that.
That's all right. First, let us complete this formality. Thereafter, we'll consider.
Obligement.
Item 22.
May I please, Lordship. As per earlier order, my lord, we have to take steps or fresh steps as per after collecting new address, but we are not able to collect the new address of the respondent number 4 and 5, and hence we have taken steps as per the address of the plaintiff, but as per record, it has been unserved. So we may allow to take another fresh steps as per after collecting the new address.
No, whether you have obtained an instruction in respect of the new address.
No, my lord, we are not able to collect yet.
Then
We'll try, my lord.
Heard, Mr.
S. U. Ahmed.
Learned counsel for the appellant, Mr. Found for the respondent number.
Respondent one, ma'am.
Respondent number 1. The learned counsel for the appellant submits that though the appellant was directed to obtain instruction in respect of the address of respondent number 4 and 5, yet the said instruction could not be obtained, and he prays for granting him some time to obtain the same. There allowed list the matter after 6 weeks. 6 weeks. It is provided that learned counsel for the appellant shall obtain instruction in respect of the address of respondent number 4 and 5, and shall take step upon them by speed post and also by usual process within a period of 1 week from today.
My lord, regarding 3, it is we are awaiting about 2 and 3, my lord.
Pardon?
We have taken steps 2 and 3 also, but we are awaiting the service.
2 and 3 shows, my lord, that it's neither ID card nor answer notice. As regards 4 and 5,
It is
shows
answered.
that,
It's answered.
it is answered.
Further, a learned counsel for the appellant is directed to take fresh step upon respondent number 2 and 3.
Item 23.
May it please, your lordship. Now, in this matter, my lord, mediation is ongoing between both the parties, and the next sitting is on 20th, my lord. So I pray, my lord, we pray that on 20th of August, maybe after 3rd week of August, my lord.
Okay, suggested that then.
28th, my lord, August. 20.
Mr. M.K. Das, learned counsel for the petitioner, and Madam for the respondent number. How many respondents are here? One or sole respondent? Sole respondent. Mr. Das, learned counsel for the petitioner, submits that in this matter mediation is going on, and he prays for listing the matter in the last part of August.
My lord.
We are allowed to list the matter on
28 August.
Deeply obliged. Interim may continue.
interim order pass earlier shall continue.
Deeply obliged.
Item 24.
We have filed amended cost title, lordship. My learned friend may appear for the disease respondent.
Respondent number 2. Respondent number 2.
21225, lordship. 2 died. 2.1 to 2.5.
Heard by Chaudhary, learned counsel for the learned senior counsel, assisted by Ms. Zia, learned counsel for the appellant, and Mr. Vardas for the respondent number 1. Respondent number 1. Mr. Vardas submits that he will be filing his power in respect of respondent number 21225. 21225 within a period of 1 week. 1 week from today. Accordingly, it is provided that this is at least the matter after 1 week.
Yes, lordship. And pro forma respondent, lordship, we have taken steps. There may not be any office note, lordship, for pro forma respondent number 3. 15/11/25 notice issued. 25/2/2026 notice served, lordship. Service complete.
When you have taken a step upon pro forma respondent number 3.
Lordship, as per my learned friend, he stated that office note dated 25/2/2026. Notice upon respondent number 3 served. Yeah, the office note says. He so service complete and LCR also received, lordship. LCR
No, that has been reflected in the order dated 27/5/26.
Lordship.
In respect of respondent number 3,
So service complete, Lordship.
yes,
If there is one more prayer, there are two interim orders that are operating, my lord. If Lordship priority last for 17/6/26. There are two interim orders that are operating. Let me complete.
okay.
Number 5.
It is also
IA
submitted at
58
her that
in IA
service
58,
in this
our
matter
interim
has been
order.
completed and the matter may be listed for hearing. Accordingly, it is provided that this is list the matter for hearing. An interim order, if any pass earlier, shall continue.
Obliged.
Item 25.
Well, in this case, my lord, TCR was called for lordship. That is not probably received. I have verified lordship,
Is here not received.
not received. Lordship.
Heard Mr. M.A. Samuel, learned counsel for the petitioner, and Madam for the respondent, sole respondent.
1 to 4. Number 1 to 40.
1 to 4.
1 to 14.
1 to 14 lordship.
1 to 14. 1 to 14.
Last order lordship.
Office note dated 15/7/2026 indicates that trial court record has not yet been received. Accordingly, it is provided that this is a issue urgent reminder to the learned trial court for transmitting the record list after 2 weeks,
4 weeks lordship.
4 weeks. Okay, 4 weeks.
Item
Inter
26.
interim may be continued lordship.
Interim order
My lord,
first earlier shall continue.
till next date of order, next date of listing lordship. Otherwise, my lord, sometimes case is not listed after 4 weeks lordship. In the meantime, my lord, the trial court, my lord, the record was put up, case was proceeded despite having my lord interim order lordship. So that is on the
Till return of
either-
date, till next date,
until further order or till next of date, my lord,
next date.
listing. Obliged lordship. In this matter, the service is complete.
Service complete. Heard Mr.
MBDI, your lord.
M. Maria, learned counsel for the appellant. And Madam, you for
The respondent number 5 lot.
respondent number 5. And Madam Burman for 4 and 6. 4 and 6. Service completed.
Yes, sir. LCR, reminder may be sent for the LCR.
LCR has not yet been received. Office note dated 15th of July 2026 indicates that TCR has not yet been received. Accordingly, it is provided that RECIS shall list the matter after 4 weeks and issue urgent reminder to the learned trial court for transmitting the record. List after 4 weeks.
Much obliged.
Item 27.
May it please your lordship. Lordship, as per office note dated 14/7/26, the notice to the respondent is delivered on 11/6/2026. The track consignment is filed as
How many respondents are here?
single sole respondent.
Sole respondent. Heard Mr.
H. Talukdar.
H. Talukdar, learned counsel for the petitioner. Office note dated 14/7/2026 indicates that notice issued to the respondent was delivered on
1/6/26 as per track consignment.
on 1/6/2026. As per consignment between bracket MO tracking report. Since but the respondent remained unrepresented today. RECIS shall list the matter after 1 week for admission hearing.
Highly opposed.
May I praise your lordship? This is the transfer petition, lordship, but the notice for the respondent number 2 is yet to be served. Yes.
No, that's I think my lord, they only want to transfer the document. Yes, from Gauhati to Sita. We have no problem. We are in for the insurance.
Lordship, respondent number 2 is necessary, I think.
Lord, what of? I'll look at it.
2 minutes time.
Who is the respondent number 2?
Demont.
Owner ID, my lord.
Yes, sir. The owner of the vehicle. Lordship.
Come driver of the vehicle.
Yes.
So is it not necessary to serve the notice upon him?
Yes, my lord. Yes. No,
Pardon?
we have no objection in this regard, my lord.
Heard Miss?
B. Devi.
Learned counsel for the petitioner, Ms. L. Sharma for respondent number 1.
1 minute.
Office note dated 15/7/2026 indicates that service report, neither AD card nor unserved notice issued to the, in respect of the notice issued to the respondent number 2 is received back by the section. However, said office note also indicates that as per postal track consignment report, the notice was delivered to the respondent number 2 on 1/6/2026. But the respondent number 2 remain unrepresented today. The learned counsel of the petitioner submits that this application is referred for transferring of MSC case number under section 24 of the Code of Civil Procedure for transferring MSC case number 3026 of 2024 from the court of, no, from the tribunal from the motor accident claim tribunal number 2 Kamrup and Gauhati to the motor accident claim tribunal in Chipsagar district. Why you were praying for transfer of this case from Kamrup to Chipsagar?
Lordship, the petitioner, the communication is very difficult for the petitioner to come to this part. She,
Actually, jurisdiction is in Sipsagar district, that's why.
yeah, and
Okay.
That's why.
The learned counsel for the petitioner submits that the petitioner, namely Oronima Sangmai, is residing at Pohukhua Gaon, Paruliguri, under demo PS of Sibsagar district.
He was a minor son also, no? He was a minor son also.
Then why you have filed the case here?
He's some out actually, out, interfered in the matter.
The learned
Yep.
counsel for the petitioner also submits that due to some misconception, the petitioner has instituted the MSC case number so and so before the court of learned. Member Motor Accident Claim Tribunal number 2 at Gauhati, Kamrup at Gauhati, and as she is residing in the interior place of Sibsagar district, it is difficult on her part to pursue the matter before the tribunal at Gauhati. And as such, she is contented to allow the petition. Ms. L. Sharma, learned counsel for the respondent number 1, submits that she has no objection in the event of transferring the MSC case number so and so from the from the tribunal motor accident claim tribunal number 2 Kamrup M and Gauhati to the motor accident claim tribunal at Sibsagar. Accordingly, taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this petition stands allowed. MSC case number so and so pending before the court of learned member motor accident claim tribunal number 2 Kamrup M Gauhati stands transferred to the tribunal, learned tribunal, to the learned motor accident claim tribunal at Sibsagar. The petitioner shall obtain a certified copy of this order and place the same before the learned member motor accident claim tribunal number 2 Kamrup M and Gauhati, and on receipt of such certified copy, the learned tribunal shall forthwith transmit the record to the learned member motor accident claim tribunal at Sibsagar. In terms of this petition is thus disposed of.
My lord, on last occasion, step was taken, it was returned unserved. But the address is, the address of the respondent is a permanent abode of the respondent. So a fresh step may be allowed to be taken by usual as well as but postal.
Madam C, as per office note dated 10/6/2026, the notice is returned with a report, no such person in the address.
But the address is a right one. We have inquired, and respondent, it is a own abode. It's a permanent resident of the place. So
Okay. Hard miss, your name,
A. Roy.
please. Learned counsel for the appellant. Office note. Not office note. Learned counsel for the appellant submits that in a person to the direction issued by this court on 12/6/2026, she has obtained instruction, and as per her instruction, the address is correct. And as such, she pressed for granting her some time to take fresh receipt upon the respondent. They are allowed. Step be taken by speed post and also by usual process within 2 working days from today. Rest is at least the matter after 4 weeks.
My lord,
4 weeks.
4 weeks.
Number 30.
My lord, the office note shows, my lord, that the pink flag, my lord, flag X1 shows that the notice has been served upon the respondent on 15/6/2026. Flag X1, my lord.
So what to do?
It may come up for admission now, my lord. X1 shows it has been delivered.
Heard Mr. Kaun, learned counsel for the petitioner. Office note dated 14/7/2026 indicates that notice issued to the respondent was delivered on 15/6/2026, but no one entered appearance on behalf of the respondent. This is at least the matter for admission hearing. Fix that on sorted.
On 31 July.
Interim may be extended, my lord.
Interim order pass early shall continue.
31.
May I please, your lordship? Lordship, as per office note dated 15/7/2026, PCR has not been received till date.
Heard, Mr.
As shown on behalf of Mr. S. Datta.
Learned counsel appearing on behalf of Mr. S. Datta, learned conducting counsel for the petitioner, and Mr.
My lord, S. Hazarika for only.
S. Hazurika for respondent. All the respondents. Office note dated 15/7/2026 indicates that TCR has not yet been received. Accordingly, it is provided that this is a issue urgent reminder to the learned trial court for transmitting the record without further delay. List after 2 weeks.
My lord, there is an interim order.
Interim order pass earlier shall continue.
34. Oh, we have entered appearance, my lord. We have entered appearance, my lord, but it's a.
Service completed.
My lord?
Service completed.
Yes. That is complete. It may come up for admission.
Admission. Heard, Mr. Your name?
Please, Rauki.
Learned counsel for the petitioner, and Mr. G. N. Sayola, learned senior counsel assisted by learned counsel for the respondent. It is submitted at the bar that this matter is ready for admission hearing, so far service is concerned. And accordingly, it is provided that recess list the matter after 1 week for admission hearing.
Item 33.
Lordship, before I am entering appearance on behalf of respondent number 4 to 13, your lordship. We are filing our wakalat in the due course of the day. So therefore, we'll be filing an.
You are for?
I am for 1 to
1 to 4.
3. 1 to 3. I am for 4 to 13, your lordship. We'll need some
Okay.
time to file our in opposition.
Okay.
My lord, challenge here is the dismissal of a 47 petition. 247 applications being filed before the learned executing court. My lord, praying that there was no recovery position in the first appellate court decree, my lord. Even though, my lord, without following the due procedural law, my lord, the suit land was recovered from us, my lord. We have been evicted and dispossessed illegally. So these 47 petitions are being disposed of, dismissed on some certain grounds which are not urged even by either of the parties. So now execution proceeding is going on. So in the meantime, if
Will you
the
fix a very short date?
Yes.
Next week?
my lord, the stay, my lord, it was all along it was stayed, my lord. Since the date of filing the 47 application, I am just praying for a short stay, my lord. Otherwise, my lord, there will be difficulty. There will be question of taking steps, my lord. And there is no question of filing.
You have already been evicted.
We have been evicted from some portion of the land. Out of the 10 cutters of land, we have been evicted from 7 cutters of land. Remaining 3 cutters of land are there, my lord. There is difficulty, my lord. They are now installing gates over the suit land. They are now protecting their own boundary. So there will be further more difficulty will arise if the execution proceeding is allowed to, my lord, go ahead, my lord. And there is no question of filing affidavit in opposition.
When the execution proceeding was filed?
Yes, my lord, it was.
When it was filed?
My lord, 2009.
9.
Title suit dates from 1989.
My lord, title suit, there was a decree, partition decree in favor of the plaintiffs. and there was a prayer for recovery of possession by one of the plaintiffs. That prayer was allowed.
Mr. Biswas, you are aware of the decision of the Supreme Court in the case of
My lord, this perimeter judgment is, my lord, somehow, my lord, we are reading in a different context, my lord. The perimeter judgment says, well, before the execution proceeding starts, my lord, order 10, the order 10, when the suit is filed, all other formalities has to be complied with. After that, the question of execution of decree within 6 months will arise. My lord, it will run prospectively, not retrospectively, because admittedly, during the filing of the suit, the order 10, my lord, procedure was not followed. All other formalities were not followed as prescribed in the Rahul S. Shah and the Perry ML judgment. And that's why, my lord, this Perry ML or the Rahul S. Shah judgment will run prospectively when, after filing the suit, the court takes into consideration the order 10 application to determine the possession of the parties. Thereafter, all the procedure will be complied with. Then the question will arise whether it can be disposed of within 6 months or not. Well, here, admittedly, there was no recovery of possession decree in the first appellate court judgment. Now they put into execution the first appellate court judgment.
Okay, we will hear you. We will hear you.
But there is no harm, my lord, if your lordship pleases to stay the operation, my lord, the execution proceeding, because all along it was stayed. If it is allowed to go ahead, my lord, it will lead to a multiplicity of proceeding, my lord.
No, we'll take up the matter in the next week.
Yes, lordship, some time may be given for us to file the objection, your lordship.
Well,
There will be a comprehensive objection, your
Well,
lordship.
there is no
And
question
even the
of.
eviction is done, your lordship. Then
Pardon?
even the eviction process is completed, your lordship, upon my instruction from the respondents.
My
The
lord,
eviction process is completed, your lordship.
Well, we have been in the trial, my lord, since the date of, my lord, execution proceeding, my lord. From half of the land, my lord, the partition procedure.
Mr. Biswas, as per his submission, execution is completed.
No, my lord. My lord, we are in the trial, my lord. We are facing the trial. We are appearing regularly in the trial, my lord. But there is a large chunk of area in the GS road, my lord. Around 7 cutters of land, we have been evicted and disposed of, my lord. There are other lands to be partitioned as per the preliminary decree, my lord. Your lordship is aware, when the preliminary decree is passed, my lord, as per order 20 rule 18, the collector has to depute some officers to allot the shares. Those procedures were not done. We have been evicted with the force of the police and the Nazir. And there was no decree for recovery of possession, my lord. And what my learned friend is asking for, praying for filing affidavit in opposition, my lord, there is no question of.
In execution proceeding, you cannot raise that issue that there is no decree for recovery of possession.
Well, in the 47 application,
Agitated before appropriate forum.
In the 47 application, your lordship is aware, my lord, 47 is, my lord, when there is a dispute between the parties regarding the execution, whether the suit land can be executed or not. My lord, your lordship is aware, in the preliminary decree, without following order 20 rule 18, whereby the collector is given the power.
Okay, let us fix it in the next week. Kobe. 24.
Your lordship, the next week, 30th or 31st, your lordship.
No, it will be too long because we are not granting any stay.
Lordship.
We can grant a 1 month time also, but in that event, we will stay the proceeding.
Lordship, 24.
24. Okay.
Lordship, requisite extra copies may be given to us. Respondent number 4 to that.
But 24th will be out of station, my lord. Can it be 21st, my lord? My lord, there is no question of filing affidavit in opposition. All the pleadings are completed before the executing court, my lord. Had it been a normal, my lord.
All right, if he want to file it, let him file. Let him file.
24 would be out of station.
21st. 21st.
From 22nd itself, my lord, will be out of station. And
27th or 28th, your lordship, because some time will be taken to prepare the affidavit, your lordship.
No, we'll take it up on 21st then.
Then, yes, my lord.
Heard Mr. Biswas, learned counsel for the petitioner. Mr. Learned counsel for the respondent number
4 to 13, your lordship.
4 to 13. Then he submits that during the course of the day, he will file his power. Mr. Daspo?
For 1, 2, and 3.
1, 2, and 3.
Respondent.
List the matter on 21st of July for final consideration.
Much obliged.
Too short of a time, your lordship. Some days.
No, you file it.
Extra copies may be given to us, your lordship.
So we have already taken steps, my lord. Bunch of documents we have supplied to the client, my lord. Their client, my lord.
No, you furnish one copy to him if available with him.
Two copies at least.
The learned counsel for the respondent number so submits that he has not been furnished with a copy of this petition. Mr. Biswas undertakes to furnish a copy of the same during the course of the day.
Much obliged.
34.
This is also out of the same execution proceeding, my lord. The two different parties are here. One is the company, one is in the individual capacity. It's the same person. So it may be fixed on the same day, my lord.
Same. 50 and 34. Okay. As agreed by learned advocates of both the parties, recess shall list the matter on 21st.
25.
Please, Your Lordship, multiple fair use office note dated 15/7/2026. Now, this again, for the second time, neither ED nor unsub notice upon the sole respondent has come back. But my prayer is twofold. Let us await the service report on the sole respondent. At the same time, my lord, I pray that this instant revision may be taken up along with CRP IO number 503 of 2025, as both these cases are intermittently connected. This actually has usurped because of the other.
What is the number?
CRP IO 503 of 2025, wherein the sole respondent in this case is the petitioner. 503 of 2025.
503 of 2025.
My lord.
Okay.
Let these two matters come up because the sole respondent here is the petitioner in that case. And they have obtained a stay in that petition.
Mr. Chakravarti, learned counsel for the petitioner. Office note dated 15/7/2026 indicates that neither a card nor unsubmitted notice issued to the respondent, sole respondent, returned till date. Mr. Chakravarti further submits that the respondent herein has filed one CRP IO number 503 of 2025. And the said matter is listed on when it is listed.
My lord, notice was issued. We have entered appearance as respondent. No date has been given. So let this matters be taken up together.
That, this matter may be tagged with the CRP IO number 503 of 2025 and may be listed after 1 week.
My lord, on a specific date, my lord.
Correct.
July or August. August also will do, but
On 31st July.
31st July.
Let's list the matter along with CRP IO number so and so on 31st.
Deeply obliged, ma'am.
Item 26.
May I please your lordship? But I have seen the office note, which says that my lord, steps have not been taken. My lord, there is some confusion. I have taken steps. I'll clarify, my lord, if steps are not being taken, I'll take it within the next 2 days, my lord.
Next 2 days.
2 days.
Heard Mr. Chaudhary, learned counsel for the petitioner. Mr. Chaudhary submits that he will take fresh step upon the respondent within 2 working days from today. Accordingly, it is provided that recess shall list the matter after 4 weeks. Step be taken by speed post and also by usual process within 2 working days from today.
I'm determined.
28.
Mm.
This is I'm appealing for all the respondents.
So service completed. Heard Miss
Timur.
learned counsel for the petitioner and Mr. Sharma for all the respondents. It is submitted at the bar that service in this matter is completed and matter may be listed for admission hearing. Accordingly, it is provided that recess shall list the matter for admission hearing after 2 weeks.
In the meantime, I filed my objection also.
Mr. Sharma submits that in the meantime, he may be allowed to file objection. They are allowed.
39.
Lordship, in this case, notice was issued on APR notice.
I appear for respondent number 1 and 2. How many respondents are here?
Lordship, 4.
4.
Government.
Circle
That
officer
was
below
given.
Tipara. Mr. Bhattacharya, you are appearing for State of Assam and Circle Officer.
39.
Yes. Okay. So service completed. Heard Miss M. Dev, learned counsel for the petitioner, and Mr. Your name, please. R. Colita, learned counsel for the respondent number 1 and 2. And Mr. Bhattacharya for 3 and 4. Since service in this matter has been completed, recessal is the matter for admission hearing after 1 week.
After 2 weeks,
2 weeks.
Lordship, interim order may be continued.
Interim order pass earlier shall continue.
Obliged.
My apologies, Your Honor. Interim order may be continued for
Okay.
item number 38.
Number 1 to 6.
1 to 6. Today.
The 40?
Of course.
Okay. Lordship will tell. Service is completed, Your Lordship.
Service complete.
Not today.
Heard, Mr. Your
He
name.
over, Your Lordship.
Learned counsel for
On his
the
submission, Your Lordship.
petitioner. And also heard, Mr.
SC count.
SC count, learned. Senior counsel? Senior counsel?
No.
Learned counsel for the respondent number 1 to 6. They submitted at the bar that service in this matter is completed and the matter may be listed for admission hearing. Accordingly, it is provided that recessal lists the matter for admission hearing after 1 week or 2 weeks.
After 2 weeks, Lordship.
After 2 weeks.
Lordship.
Okay.
That may be fixed. No.
Item 42.
May I please, Your Lordship?
Yeah.
My lord, this is a case where I had filed a petition under order 711 of the CPC, my lord, which was rejected, my lord. The case is like this, my lord, the respondent here was the judgment debtor in the original suit, my lord. That decree which was passed by the trial court was affirmed by the first appellate court and it was, my lord, affirmed by the High Court here in RSA, my lord. And when
In
the
second appeal.
in second appeal, my lord. Then the second appeal was withdrawn, my lord. Thereafter, my lord, they out of their own vacated
no,
the
no,
lands,
no.
my lord, and I went there
After
and
disposal of the RSA, it was withdrawn.
no, my lord.
Before
RSA was before disposal, it was withdrawn, my lord. So, my lord, the decree which was passed, my lord, and which was affirmed by the learned appellate court, that remained intact, my lord. Thereafter, they vacated the area, my lord. We went there and we took in possession, and since 1 year we are there in possession. Now they have filed a suit saying that, my lord, that without due process of law, we have been evicted. And even in the suit, if your lordship kindly sees the plaintiff will see that on 30th of January, they said that they have been dispossessed and they have come up by a petition under section 6 of the specific relief act in the month of August, my lord. In the last page, your lordship will see, my lord, the date, my lord, on which that suit was filed, my lord. That is that CEC.
But the other side is absent, no?
Other side is absent, my lord. We have taken steps, my lord. And today, my lord, in the earlier orders of the court, lordship will kindly see, my lord. I made a prayer, my lord, that, my lord, the further proceedings of this suit may be kept in abeyance, my lord. And that, my lord, in the previous order, it was stated that today it will be considered, my lord. The next date is fixed the day after tomorrow on 21st. So my prayer before this honorable court today is, my lord, that further proceedings may be kept in abeyance, my lord.
Or Mr. Sodore, learned counsel for the petitioner. Office note dated 15/7/2026 indicates that neither ID card nor unserved notice issued to the respondent returned till date. You want to take fresh step upon the respondent?
No, my lord, let the service report be awaited, my lord.
List the matter after 2 weeks awaiting service report upon the respondent. Mr. Sodori has pointed out to the order of this court dated 22nd of June 2026 and submits that his interim period may be considered today in view of the said order. But it appears from the paragraph number 5 of the order dated 22nd of June 2026 that interim period will be considered only after service of notice.
We have taken steps, my lord. My lord, it's fixed on 21st, my lord. Kindly consider, my lord. 21st. 21st.
No, without service of notice, how can?
Well, because lordship will kindly see, my lord, even for a suit of specific performance, I have given the plaint.
No, that's all right. In the order itself, it is reflected that it will be considered after service of
Actually,
notice.
it was, my lord, stated by the learned court on
On
that
that
day, my
day, you
lord,
could have
it
raised
was-
objection.
It was stated that you take the steps, after taking steps, we will consider on the next day. That is why, my lord, the learned court wanted my lord to me to, my lord, to find out the next date. So when I said it was 21st, it was fixed on 17th, my lord. By that way, it is my prayer, my lord, kindly stay the further proceedings, they will appear, my lord.
No, if we.
Because ultimately, your lordship will kindly see one thing. So, my lord, whatever it is, my lord, when we file a suit, my lord, we allege certain rights, my lord. When in respect of the same property, when, my lord, you have suffered, my lord, a decree, my lord, up to the High Court, my lord. Thereafter, what is the right involved there, my lord, for which you can stay?
No, that's all right. Merit we will consider.
My lord.
But this rider is there.
My lord. No, my lord, that rider may be there. No, I am making a fresh prayer today before your lordship, my lord. Then
No,
let it be
if we
considered, my lord.
frequently ignore the order, then it will
No,
transmit.
I'm not telling to ignore the order, but my lord, because the facts is like this, my lord, it is fixed on 21st.
If there is urgency, you file one IA, then we will consider. But on the face of the order of dated 22nd of June 2026, it is
And because in
difficult
this
for-
order, my lord, the impugned order of Order 7, Rule 11, my lord, by which my petition was rejected, that thing was not reflected. That, my lord, the
Anyway, you
plaint
take a
itself
step,
shows.
we will consider.
My lord.
We will consider. You serve notice by dusty mode.
Yes, my lord.
Additionally, dusty service is also permitted. After effecting service by dusty mode, the petitioner shall file an affidavit before this court. List the matter on fixed date.
29 July.
29 July.
27.
27.
Item 43.
On that day, my lord, this interim prayer will be considered. One line only, my lord.
No, that rider is there.
Even from this court, my lord. If one line is stated that on that day it will be considered after service, my lord, it will suit my purpose, my lord.
You file an IA, we will consider it.
My lord.
No, but in this matter also, my lord, notice was issued against the impugned order. And notice has already been issued, but no report has come up. But my prayer is that, my lord, on the earlier occasion, because there is the execution case is pending, my lord. I am the judgment debtor. And the similar and same subject matter between the same parties. The decree holder has filed another case for cancellation of my sale deed. And lordship will find the impugned order page 82. The petitioner has filed an application under Order 21, Rule 26 for stay of execution of the execution case, my lord. But the learned executing code, Civil Judge Junior Division number 2, Kamro, Civil 1, page 83.
No, Mr. Nath, you see, service is yet to be completed here.
Yes, my lord. But, my
Or
lord,
Mr. S. Not learned counsel for the petitioner.
that's
Office note dated 15/7/2026 indicates that neither edit card nor unsert notice issued to the respondents returned till date.
they can next date.
You want to take fresh step?
No, my lord, then Dusty may be given, my lord. They are of the same locality.
Okay.
Because, my lord, it is
List the
just
matter after 2 weeks awaiting service report upon the respondent, and additionally, dusty service is also permitted. After effecting service by dusty mode upon the respondent, the petitioner shall file an affidavit before this court. List after 2 weeks.
that date may be given, otherwise, my lord, it is.
Take a date from here.
Let's see. Publish.
44. I am making
Service.
yesterday I have filed Authorised. Take the matter come up for admission.
Admission hearing. Heard Ms. Bhattacharya, learned counsel for the petitioner. Mr.
I am DK Bagchi.
DK Bagchi, learned counsel for the respondent. Since service in this matter is completed, let's list the matter for admission hearing. After 2 weeks,
After 2 weeks, later 4 weeks, my lord.
After 3 weeks.
Madam, what is it?
Okay, we have filed two IL also. One is this 1864/26 Lordship. It is for substitution of the legally of the respondent number 14 Lordship.
Lordship, I am for the respondent number 1 and we don't have any objection for this.
IA number?
1864.
This is for substitution.
Yes, Lord.
Heard Miss Sarullah, learned counsel for the petitioner, and also heard Miss
H. Kavita. Himatri Kavita.
learned counsel for the respondent. Opposite party. This application under order 22, rule 4 of the Code of Civil Procedure is preferred by the applicant for substitution of legal heirs of the respondent number 14 who suffered demise on when he died?
14/4/26.
14/4/2026. The learned counsel
Page
for
number
the applicant submits that the applicant has preferred one regular second appeal being RSA number 175 of 2025. And in the said RSA number 175 of 2025, the respondent number 14 suffered demise, and as such, there is a requirement of bringing on record the legal heirs of the respondent number 14. And as such, he has contended to allow this application. The learned counsel for the opposite party submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The legal representative of respondent number 14 be substituted in the RSA number 175 of 2025. In terms of above, this IA stands disposal. In view of the order passed in this IA, the learned counsel for the appellant shall file amended cause title of the RSA number 175 of 2025 within a period of 1 week from today. Amended cause title.
10 days.
10 days.
Yeah. But the second IA Lordship 1865.
Yes.
This is for amendment of the cause title of the in respect of the new address of the respondent number 3 and 4. Because the service returned that the address he left the place, and we have collected the new address and we have filed this application.
Heard Ms. Avullah, learned counsel for the applicant, and also heard Ms. Kolita, learned counsel for the respondent. This application under order 6, rule 17, read section 151 of the Code of Civil Procedure is preferred by the applicant for amendment of the cause title. So far it relates to the address of respondent number 3 and 4. The learned counsel for the respondent submits, opposite party submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The learned counsel for the applicant shall file amended cause title in the same RSA 175 of 2025 within a period of 10 days from today.
Obliged.
47.
My lord, in the earlier suit filed by the respondent, my lord, we filed 7 documents, my lord. Now we have filed a suit, my lord, for eviction of the respondent. In that suit, we require those documents. Earlier, my lord, we filed an application before the National Court to withdraw those documents, my lord, by filing it attested copies. But my lord, the National Court allowed us to adduce secondary evidence. Now we filed the petition, my lord, for secondary evidence. The learned trial court allowed 4 documents, but 3 documents were not allowed as secondary evidence. So I pray, my lord, that these 3 documents, exhibit B, C, D, may be allowed to be withdrawn by keeping, my lord, the attested copies in this record, my lord, second appeal, so that we can exhibit the same in the title suit filed by us, my lord.
So Chakraborty, any objection?
My lord,
No
I
objection.
do not have objection, but then whether the order that was passed by the learned court below, rejecting their application under section 66 of the Evidence Act, specifying that those documents which they wanted to bring, those documents which were not allowed. Now that has been stated to be vague documents. And now, my lord, this is now being clarified in this IA that those documents pertaining to exhibits B, C, and D of the. So whether those documents are really those documents or not, this is something whether, my lord, this.
No, that is not the subject matter of this interlocutory application.
We shall submit, my lord, attested copy.
The trial court will look after the
Yes,
same.
admissibility of the documents, my lord, will be taken care of. If that observation.
No, why should we consider?
Otherwise, my lord,
No.
coming from this
So
honorable court.
he will have, my lord, no difficulty because attested copies will be there. So.
Heard Mr. Sayola, learned senior counsel assisted by Ms. So learned counsel for the applicant. Mr. Chakraborty for the opposite party.
Only one.
Opposite party number 1. 2.1 to 2.3. This application under section 151 of the Code of Civil Procedure is prepared by the applicant for releasing document number 2, 3, and 4.
Well, 2, 3, 4 is the exhibits B, C, and D.
Which were exhibited as exhibit B, C, and D before the learned trial court in title suit number 133 of 2010.
Yes.
Which were tagged along with RSA number 128 of 2024. Which has already been disposed of. RSA?
Yeah, well, RSA is pending.
It has been
Okay.
admitted, it is pending.
Which is pending before this court. Mr. Sayola submits that the document number 2, 3, and 4, being the exhibit B, C, and D, are required to be exhibited before the learned trial court.
Trial court, my lord.
In connection with?
In connection with, my lord, another suit, my lord, filed by 66 of 22, title suit.
In title suit number 66 of 2026.
22.
2022.
5 weeks of that.
And as such, he has contended to release the document number 2, 3, and 4, which are exhibited as B, C, and D, by keeping the attested copies of the same with the record of RSN number 128 of 2024. Mr. Chakraborty submits that Chakraborty and Mr. Abortazazi submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that the document number 2, 3, 4, being exhibit B, C, and D, entitled suit number 133 of 2010, tagged with RSN number 128 of 2024, shall be released, keeping the attested copies of the same along with the order, along with the RSN number 128 of 2024. In terms of above, this RSA stands, this I stands closed.
Well,
Like. Item 53. For item 50.
Nothing, sir. Matter ought to have been come for hearing also.
Pardon?
This matter ought to have been listed for hearing also.
Service completed.
Lots of complete.
Heard, Mr. Your name, please?
M. Boro for R. Ali Lodge.
M. Boru, learned counsel appearing on behalf of Mr. R. Ali, learned counsel for the appellant, and also heard Miss learned counsel for the respondent.
Respondent number 1.
Respondent number 1.
My lord, the date for hearing kindly be given after 15th August.
And not on Friday, except Friday.
Lodge, if possible, 8th September Lodge.
It is submitted at the bar that in this matter service is completed and the matter may be listed for hearing. Trial court record received.
Yes, Lodge. This is already in record.
Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that RSS shall list the matter for hearing on
8th September.
Item 53.
Yeah, please allow. Here allows me to take fresh steps upon respond number 2, 3, 4, and 5.
But Mr. Vardas, learned counsel for the appellant, and Ms. Learned counsel for the respondent number 1.
One lordship.
1.
Been received lordship in this matter.
Office note dated 4/6/2026 indicates that service report in respect of respondent number 2, 3, 4, and 5 are still awaited. Said office note also indicates that the LCR has been received. You want to take fresh
Yes,
essay?
yes.
Mr. Vardas, learned counsel for the appellant submits that he will take fresh essay upon respondent number 2, 3, 4, and 5. Accordingly, it is provided that step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
4 weeks. I'll
That is, I will think for the respondent.
Service completed.
Come up for a question. The date will be fixed.
Both the parties are represented by their engaged counsel. Since service in this matter is completed, recessal is the matter for admission hearing after. Okay.
On 19th August,
19th August.
item 55 and 56.
Petition for IF for early hearing, my lord.
Any objection? No objection. Heard, Mr.
L data.
Your name?
L data.
Learned counsel for the applicant and Mr. SR Bormaya, learned counsel for the respondent. This application is preferred for early hearing of RSA number 165 of 2022.
165 and 164.
Both the matter.
Both the matter.
165 of 2022 and 164 of 2022. Having heard the submission of learned counsel for both the parties, this interlocutory application stands allowed. Recessal list the RSA number 164 2022 and 165 of 2022 on for hearing on 10th of September.
Item 4, item number 8.
Can the matter have taken up any lordship? My senior Mr. K.K. Mohan will be arguing the matter because
Who is your senior?
Mr. K.K. Mohan will
Item 9.
May it please your lordship. This petition has been filed for transfer of divorce petition filed by the petitioner's husband in Morrigaon to Sibsagar lordship. My main ground is that they have never stayed together in
The
Morrigaon. my
transfer
lord.
from Morrigaon to
Sibsagar, my lord.
Sibsagar.
Lordship. Though we have filed a affidavit in opposition, we do not have any objection to this transport matter.
No objection.
My staff will look into my planning, Lordship. Lordship, we find that of your order.
Okay. Heard, Mr.
Is Rahman lordship.
Learned counsel for the petitioner and Mr.
He does.
T does learned counsel for the respondent. This application under section 24 of the Code of Civil Procedure is preferred by the applicant for transferring title suit within bracket D number 75 of 2024 from the Court of Learned District Judge Morrigaon to the Court of Learned District Judge at Sibsagar. The learned counsel for the petitioner submits that applicant submits that the respondent herein is the husband of the applicant who has instituted title suit D number 75 of 2024 before the Court of Learned District Judge at Morigaon. But the applicant herein is residing at Shivsagar.
Yes, sir.
Shivsagar, and as such, it is difficult on her part to pursue the aforementioned proceeding in the court of district judge at Morigaon. And under such circumstances, he has contended to allow this application by transferring the title suit D number 75 of 2024 to the Court of Learned District Judge at Shivsagar. Mr. Das, learned counsel for the respondent, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this application under section 24 of the Code of Civil Procedure stands allowed. Title suit number D 75 of 2024 pending before the Court of Learned District Judge Morigaon stands transferred to the Court of Learned District Judge at Shivsagar. The petitioner shall obtain a certified copy of this order and shall place the same before the Learned District Judge at Morigaon, and on receipt of and on such certified copy being filed, the Learned District Judge Morigaon shall transmit the record to the Court of Learned District Judge at Shivsagar. In terms of this, this transfer petition stands disposal.
Obliged, Lordship.
11.
Please, Your Lordship, kindly matter may adjourn for the day as my senior is unable to appear today.
Why?
He is out of station due to medical issue.
Who?
SP Chaudhary.
Heard, Miss?
D. Das.
Learned counsel for the petitioner and Mr. For the respondent. 1 and 2. 1 and 2. 1 and 2. Miss Das submits that conducting counsel, Mr. Soduri, SP Soduri, is out of station and as such, he has contended to adjourn the matter to be listed after.
Any day.
Maybe fix next week.
When?
Next week. Next week.
When?
Any date, Lordship.
Next week.
Okay.
34, 29. 29.
29th. Yes,
Lordship,
yes,
interim may be continued.
interim order for orders and continue.
Okay.
Item for hearing under order 41, item 13.
Your Lordship, like last occasion, Your Lordship directed the appellant to file deposition on court by filing additional affidavit. Accordingly filed. And it may be in the case of regarding during pregnancy, no any amendment has been made for recovery of possession. But learned trial court, without pleading, beyond pleading, passed the judgment by allowing the pair of recovery of possession. Your Lordship, to that aspect, the deposition of the PW and DW directed to file. As per the evidence, it is that established that the plaintiff respondent never in position from the all deposition. The ground number 4 of my memo of appeal. I have taken the plea.
Before the first appellate court, whether you have raised this issue that there was no pair for recovery of possession?
Yes. They have played two pair in the plane. First is recovery of possession, declaration that they are in possession.
Where is the plane? Where is the plane? Page
Yes,
number?
kindly. Page at page 68 and pair person at page 75. Kindly pair number 1. Lordship, find it. Page number 75.
Yes, got it.
First pair, internal page 8 of the
Declaring that plaintiffs have right, title, interest, and possession.
Yes. On the suit land, described in the schedule B of the plane. But in pair number 5, it is further alternatively prayed that if during pendency of the suit, the plaintiff are dispossessed from the part of the suit land or from the whole of the suit land, delivery of possession of the suit land be given to the
Pair is
plaintiff.
there.
Yes.
Pair
but
is there.
there are no any avertment that during pendency of the suit, the defendant disposes the plaintiff. No amendment sought for. No any statements. How did the trial court has given the pair?
What is that evidence?
Evidence, only additional affidavit. Start from internal page 114.
114.
114. It was filed. PW1 117, 117.
117.
PW1.
And which is the relevant paragraph?
In SIP 1118. 1118.
Paragraph number?
Paragraph number, third paragraph. And paragraph, fourth paragraph, last sentence. They say the Honorable Court passed the order directing both the parties to maintain status quo or the suit till disposal of the suit. Even after subsequent order passed by this Honorable Court, the main defendant has been threatening the forcefully disposes us from the suit land, and we have been maintaining possession of the suit land till today. That is their version. My lord, turn into the page. In the cross examination. Cross examination in typed copy start from DW 122 page number, and relevant part is 123. My lord, first paragraph, last sentence. I do not know if the suit land is now, the suit land is under possession of the defendant. Now next, I have no objection if the commissioner inspect the suit land upon the pair made by the defendant in court. That means they have no in possession. And thereafter, other witness.
No, you see, if the land is now, the suit land is under the possession of main defendant.
Yes. We are defendant. The plaintiff claimed that they are in possession, but in practical, single minute they were not possession. Other evidence also, I am coming to this point. Page 126. Cross examination of PW2. Second paragraph.
Now the plaintiff have
no possession
no
of in the suit
possession in
land.
the suit land.
The plaintiff were kicked out by the people, physically assault. Their claim. but no statement in the pleadings. And other witness also, kindly turn into the page. DW1. Page number 128. DW1 shift. A paragraph 4, internal paragraph 4, DW1. Page number 128. A paragraph that prior to the execution of registered sale, an agreement was made on 30th day of September 1989, and on the same day, possession was delivered by the landlord.
Page number 30.
128, page number.
Which paragraph?
Paragraph 4 and 5. Internal paragraph. In paragraph 5, that I am in possession since then till this date. Paragraph 8 also. That I have kept my possession on since the delivery of possession till this date without any interruption. Dependent are in possession. And DW2 also. Next paragraph. Page.
Okay, okay. So, how many substantial question of law are being suggested here?
In ground number 4, that without pleading, I have taken the plea. Ground number 4.
No, it cannot be said that there is no pleading. They have prayed for in the pair person that in the in the event of a disposition.
That means possession or not possession. Suppose they 2 times paid. One is the alternative paid is recovery possession. If alternative pair will be
one pair is for declaration that they are in possession.
Possession.
And if in the meantime they have been dispossessed, then for recovery of possession.
But there is no pleading when they were dispossessed. By what process, by when, there are no pleadings. But trial court has, without pleadings, allowed the pair of recovery of possession. Without beyond pleading, the learned trial court has.
You have filed amended cause title here?
Yes.
When?
In plain. Yes.
Amended.
Pair cause title.
Here, which substantial question of law will deal with this issue?
Substantial for the learned, whether the learned trial court.
No, where you have averred it?
I have given the paragraph
Question
4,
number?
paragraph number 4.
Substantial question of law number 4.
Paragraph number, page 11, ground number 4. I will read over.
So only one substantial question of law will be sufficient?
Other maybe also the non-joint of necessary party, but learned, your lordship has decided that it is not a mandatory.
Then
okay, and other
okay.
3 also. The suit line has ground number 3 also. The without being partition, as per section 44, without being partition of the entire land among the legal heirs, no property can be transferred as per section 44. This is also my 2 ground. Take before your lordship.
His share he can. In the joint property?
Yes.
Co-owners can.
Yes, entitled to
His
get
part
share.
of his share.
Yes, without being
there being
partition.
any partition.
Yes.
Okay, we'll pass the order.
Must have.
Can I be taken up at 2, my lord?
Itu, sir.
15. Can it be taken up at 2, my lord? Mr. Sharma is there, but he has that something.
Okay.
I'm okay.
Take that.
In his absence.
No. At first you entered appearance, you filed your written statement against the counterclaim.
My lord.
Subsequently, you have defaulted.
No. So far as the
And notice was issued, the process server did not find you.
My lord.
Then.
Well, I'll come to that. Whether the process server report in that manner could
No,
be accepted.
that is not the subject matter of challenge in this petition.
No, my lord. Process server's report, whether that can be accepted so as to proceed against the plaintiff is a subject matter, my lord.
No, are you challenging that order here?
Yes.
Process server's report.
Yes, my lord. I am not saying that process server report I am challenging. I am saying that when the court proceeds.
Even then earlier you have entered appearance.
My lord. Now, true, my lord, lordship is absolutely correct that earlier I entered appearance, I was aware of the counterclaim.
Then why not it should be a bi-party proceeding?
My lord, the order itself shows that it is proceeding ex parte against me.
Maybe.
But my lord, lordship, I am putting a question to myself. How do I know that the counterclaim is taken up? Because the order by which
you know that your suit was dismissed.
Yes.
For default.
Yes.
You also know that one counterclaim is also filed there.
My lord, after they filed a caveat against the decree was passed, ex parte decree was passed. After that, they filed a caveat. I received a notice of the caveat. Then only I came to know that there is an ex parte decree against me. My lord, I am putting a question to myself. If the suit is dismissed for default and no order is passed with regard to the counterclaim, subsequently after 1.5 months on an off date, if the defendant files an application for taking up the counterclaim because no order was passed as to counterclaim, whether it can still be said that I have got notice, my lord. My lordship may straightway come to the order. Page 64, man. This was the order by which the suit was dismissed for default, man. Page 64, man. May I read, man? Page 64. 14.9.
No, Mr. Mazumdar, you say here you are challenging the order passed under Order 9, Rule 13 of the CPC.
My lord.
But the problem is that several decision of Supreme Court is there.
My lord.
That this order is appealable order.
That's why, my lord, I want to take that objection initially.
No, you are not raising any objection.
No,
my lord, here the facts are slightly different, my lord.
He wants to
order 9,
for himself.
my lord, my order 9 rule 13 application has not been dismissed. I filed an application for condonation of delay because there was a delay. Now, while taking up the application for condonation of delay, court says that your order 9 rule 13 is not maintainable. So your section 5 petition is also not maintainable. This is the order I am challenging before lordship, my lord. Not the order passed in order 9 rule 13.
No, that's all right.
Yes.
By dismissing your application for condonation of delay.
Yes, ma'am.
The other application is also dismissed.
Yes.
So that is the order passed in this application also, or Order 9 Rule 13 also.
Yes. That is because my Order 9 Rule 13 petition is held to be on contest, and therefore this Order 9 Rule 13 is not maintainable. Therefore, Section 5 application is also dismissed as not maintainable. So my application under Orders 5, Section 5 of the Limitation Act for condonation of delay has been actually first taken up. That is dismissed on the ground that your Order 9 Rule 13 application is not maintainable. And that is because it is mentioned in the ex parte decree that it is on contest.
So we will hear the matter on the point of maintainability.
Yes.
You satisfy this court?
My lord, my lord.
And Mr. Mohanto, do you have the recent decision of the Supreme Court delivered by Justice
In fact,
Ujjwal
my
Bhuiya and
lord,
Nagaratna?
my lord, there is some confusion about this. I have filed this revision before lordship, and I have simultaneously also filed an appeal before the court below where the appeal will lie. Because there is some confusion. Confusion arises because, my lord, had it been a simple order of rejection of section order 913, then appeal lies.
And
Here, my lord,
there is a three-judge bench decision also in the year 2004, perhaps.
my lord. No, my lord, that proposition of law is correct. My difficulty, lordship, will kindly go to the order, my lord. My difficulty arises from there. Lordship will kindly go to page 112. 112, my lord. Just one page practically order, my lord. Just one page. Page 112. Parties are represented. Heard the submission of learned counsel appearing for both sides. The instant miscellaneous J case has been registered on a petition number so-and-so, dated so-and-so, filed by the plaintiff under section 5 of the Limitation Act, praying for condoning the delay of 312 days in filing the application under order 9213 CPC, for setting aside the ex parte judgment and order dated so-and-so, and to allow the plaintiff to contest the suit. I have perused the content of the petition as well as written objection filed against the petition. In support of his submissions, learned counsel for the plaintiff has relied upon the three judgments of the Honorable Supreme Court reported in so-and-so. I have perused the judgment dated 28/2/2018 passed in title suit number so-and-so. The order portion of the judgment in para 21 of the page number 13 reads as follows. In the result, the counterclaim is decreed on contest with the following relief to the defendant number 1 and 2. The aforesaid operative part of the judgment makes it abundantly clear that the counterclaim has been decreed against the plaintiff on contest. The plaintiff could have taken recourse to Order 9 Rule 13 CPC only if the counterclaim had been decided ex parte against the plaintiff. Situated thus, the instant petition filed by the plaintiff for condoning the delay in filing the petition number so-and-so is not maintainable and the same is rejected. So if the delay condonation petition is not rejected in this manner, then I can file an appeal. And I have, because of this confusion, my lord, I have simultaneously filed an appeal that is pending. If your lordship holds.
And if alternative remedy is available, then how this petition under Article 227 maintainable?
My lord, my difficulties, so far as.
No, you may have many difficulties.
My lord.
But we are difficulty in the entertaining this petition under Article 227. Once you are availing the remedy before the alternate appellate court, and you are also filing revision here. What is this?
My lord, my lord, I have come against an order passed under section 5 of the Limitation Act. This is the problem, my lord. If petition is Order 9 Rule 30 petition is taken up and held, that it is rejected or this, then matter is different. Here, my section 5 petition is, my lord, rejected. Now, against that, can I go to the appellate court? This is my problem. Order 9 Rule 30 petition has not been rejected first. My section 5 petition has been rejected. My lord, against this, supposing
thereby your petition under Order 9 Rule 13 is also dismissed.
True, my lord.
So that order is also an order passed in your application under Order 9 Rule 13.
Yes. Now, my lord, supposing, my lord, this is the difficulty for which I have filed both when there is a confusion. Supposing, my lord, I go to the appellate court because I have already filed an appeal also. Supposing I go to the appellate court saying that I have come against an order rejecting my Order 9 13. Court may say, see, your Order 9 Rule 30 petition has not been rejected. Your application under section 5.
You go and avail that remedy. You pursue that remedy. This petition is not maintainable.
My lord,
Not maintainable.
I'll do that, my lord. Once your lordship passes that order, I'll pursue my appeal. My only difficulty is, my lord, if the code of appeal below says, let's see, your.
I am referring a decision of the Supreme Court.
My lord. No, it is what of people like. My lord, this appeal lies under order 43 rule 1 only. Which your lordship is referring, my lord. My lord, lordship will kindly have a look at order 43, my lord.
See, latest decision is not latest. It is Muhammad Ali versus V. Zoya 2022 Live Law SC, page number 574.
My lord.
Supreme Court has stated that petition stroke revision under Article 227 would not to be entertained when a statutory alternative remedy by way of appeal is available under the Code of Civil Procedure.
My lord, I am not disputing
You are,
that.
you are availing the remedy there.
My lord, your lordship is absolutely correct. I am just trying to impress upon your lordship that your lordship is absolutely right. This statutory appeal by Honorable Supreme Court is referring to is under Order 43, Rule 1D. Lordship will just have a look at this CPC, my lord. Order 43, 1D. I am conscious of that, my lord. In spite of that, I had my lord, I had to file this revision under certain circumstances that I am trying to explain to your lordship. Order 43, Rule 1D. This provision itself is clear, my lord. Order 43, Rule 1D, my lord. An order under 13 of Order 9, Rule 13 of Order 9, rejecting an application in a case open to appeal for an order to set aside a decree passed ex parte. My lord, there is one more difficulty. This appeal will lie provided it is passed ex parte. Court has now already held. Let's say it is not an ex parte decree. There is already a finding, my lord.
No,
It is not an ex parte.
Sometimes you are saying that it is bi-party order. Sometimes you are saying that it is ex parte order.
No, my lord. According to me, it is ex parte. The court which has passed the decree has mentioned on contest. I just point out two things, my lord. Lordship will pass the order. I'll just mention two things. Lordship will kindly see this page 64. Lordship has seen, my lord. 64, na? Page 64, just for a moment, my lord. I'm just three orders I'll show, my lord, then your lordship will kindly pass the order, my lord. 64 is very clear. It says, I have no difficulty in pursuing the appeal also. So if my grievance is taken care of, but here there are some difficulties, that's why I'm saying. And lordship will kindly see page 64. Seen the report of Advocate Commissioner stating that PW1 is not turning up for further cross-examination since long time, and today he is absent without stay. The Advocate Commissioner accordingly prays for passing necessary order. The plaintiff has not paid the amount of cost imposed upon him in earlier, as the plaintiff is absent today and has not turned up to face cross-examination while the suit is fixed for hearing. Suit of the plaintiff is dismissed as provided in Rule 8 of Order 9. That is reason for default. Lordship is aware of that, man. Order 9, Rule 8 says reason for default.
There is no reflection about counterclaim.
In this order, my lord, there is no reflection about the counterclaim as to when the counterclaim will be taken up. I am not aware. Even if, my lord, supposing, my lord, on that day I failed, I could not go. Lordship may say that next day you could have gone and found out what is the next date or what is the status of your case. For 1.5 months, there is no order as to the counterclaim. Now, Lordship will kindly see page 65, next page, my lord. This is an order of 4/11 after almost 1.5 months, 2016. Case record is put up today with petition number 45 filed by the defendant number 1 and 2. stating inter alia that in order dated 14/9/2016, suit of the plaintiffs was dismissed, but defendants have filed counterclaim and the same is required to be proceeded with. It appears from the record that the defendants have filed counterclaim and against the same. Plaintiff has also filed WS and issues have been also framed, but while dismissing the suit of the plaintiff, inadvertently it was not reflected in the order dated 14/9/2016 that the counterclaim will proceed as per law. And as such, the instant petition to proceed with the counterclaim, further with the counterclaim is allowed. The issue number 1 to 13 framed as regards suit are hereby struck off. Issue court notice to the plaintiff with regard to counterclaim. Since the plaintiff is absent without step, court is aware that I am not appearing. Court is aware that defendant also have not been appearing for 1.5 months. Now court says that issue notice to the court. Now, Lordship, can you see the next page, page 66. The next order, 21/2/2017. Court notice issued to the plaintiff, and it is reported that at the given address, the plaintiff, Gyan Sagar Foundation, it is an office, was not found. Very vague, my lord. It appears from the court notice that the same was sent to the address given by the plaintiff itself in its plaint. It also appears that the plaintiff has already filed his written statement against counterclaim of the suit, but since the suit is dismissed, the plaintiff stopped appearing in the suit. Situated so, the counterclaim shall proceed in the absence of the plaintiff. Court is again affirming that now it will proceed in the absence of the plaintiff, that is ex parte. Court is aware of that. Now, the only question before your lordship is, my lord, when the process server issue report that in the given address plaintiff was not found, whether that is complete or whether the court can assume that the notice is served. For that, my lord, I am only relying on order 5, rule 17.
Mr. Mr. Majumdar,
My lord.
You see, if the petition itself is not maintainable, why should we go to the merit of the matter? You are arguing on the point of merit.
What I am trying to project before lordship is, my lord. It is not a case where order 9 rule 13 petition has been rejected on merit. It is a case where
maybe even then it is rejected. It amounts to rejection.
Amounts to rejection, but then fact remains that, my lord, this order section 5 application has been taken up, and that has been not considered on merit. Court says that since your order 9 rule 13 petition is not maintainable because it is not an ex parte decree. So it has been decided that it is not an ex parte decree in an application under section 5. My submission before lordship is section 5 application should have been taken up. After condoning, or if it is rejected on merit of section 5, no difficulty. If it is allowed, then the court will enter into section order 9 rule 13 petition. There, if the court holds that, see, I am now taking up your order 9 13 petition, but according to me, it is not maintainable because according to me, it is an order on contest. Against that, I will go before the appellate court. No difficulty, my lord. But the court did not go into that procedure. Court says that, see, I am taking up your application under section 5. I am not going into the merit of section 5, whether you have been.
That petition is yet to be disposed of. That is pending there.
Which petition, my lord?
No, that appeal is pending there.
Appeal is pending because we have informed the appellate court, my lord. Let's see, because of this confusion.
Simultaneously, against the same order, you cannot be.
No, my lord. No. My lord, let me clarify. I have not filed two simultaneous petitions. We have specifically mentioned to the appellate court that as far as we are concerned, there is a confusion as to whether appeal will lie because of the nature of the order or a revision will lie. That is why, as a measure of abundant precaution, we have filed this appeal, but in a revision, the honorable court will still to take the call and take a decision.
Now, now it is your apprehension that appeal may not be considered by the trial court.
No, my lord.
Therefore, you are pursuing this petition.
Same day we filed. We have, but I have no difficulty in pursuing the appeal because I want to challenge the order 9 13 order ultimately. But here is a case, my lord. My section 5 limitation application has been taken up first. That has been decided not on merit. Not on merit. Court says that since your application under order 930 is not maintainable, so I am dismissing it. Court did not enter into the question as to whether I have been able to explain the delay of 312 days. That is why I am before Lordship. There is a confusion as to, in such a circumstance, whether appeal will lie or revision will lie. That is the reason we filed the revision application.
Oh, we will not entertain this petition. You go and pursue the appeal.
My lord will then clarify that whatever finding given by the court below with regard to this limitation, because limitation court has already recorded some finding.
Whatever prayer you have made there,
My lord.
that is not before this court. Why should I record it here?
No, my lord.
Regarding delay.
Whether your appeal is a part of this record.
No, my lord. Delay, court has disposed of the matter without going to the merit. Court has dismissed my petition. Now,
No,
if I go to the...
we will not record any finding in respect of the merit of the matter.
No, I'm not saying that merit.
We are simply saying that this petition is not maintainable as you are availing alternative remedy.
That possibly is factually not correct, my lord.
Maybe.
I have not availed the remedy because I want to simultaneously. My lord.
Yes, Mr. Mondo, anything to submit?
Yes,
Just one more sentence before my learned friend starts. We have filed the appeal only against the order passed under Order 9/13, saying that it is not maintainable. Only against that, not against this part. So far as this rejection of application under Section 5 is concerned, that is not the subject matter before the appellate court, my lord.
If I may say so now, well, understand has said that this is a part separate from the appeal. It merges. Unless the condonation is done, appeal cannot be taken up. And when the condonation is rejected, appeal automatically gets rejected. He has gone on appeal against the original order. So both the things will come together. Order 9 rule 13 is seeking the relief. Law is very specific. He has placed the law. Lordship has seen the law. The both order 9 rule 8, order 9 rule 13. Application C rejected, appeal times. Specific. That has been, if the condonation petition is rejected, then appeal gets rejected automatically. Or the petition gets rejected automatically. Order 9 rule 13. So it includes both. In my submission to my understanding, there is no difficulty. When he has gone on appeal already, he can ventilate his ground there. Then appeal takes care of all. Why this honorable court should observe something? No. When the petition itself is misconceived, not maintainable, and alternative remedy is there, this decision also referred to that posting mutually
yes.
housing society.
Yes.
The same ground, same facts. Condonation petition was rejected. They came by filing revision under 115. Agreeing that my condonation petition has been rejected, therefore it must be rejected. Which was accompanying the order and rule 13. High Court allowed it. Apex Court said sorry. You have exercised this jurisdiction, which was not to have been exercised because there is a specific remedy available under the law. That's why my submission is, when the law is very specific, there should not be any confusion. He has gone on appeal. Let him pursue the appeal. Appeal will take care of what is Lordship has referred to. I would like to again point out. Here, in this order, situated thus, the instant petition filed by the 113, page 113. Last few lines. Situated thus, the instant petition filed by the plaintiff for confirmation of delay in filing the petition under order and rule 36 is not maintainable and is saying is rejected. So and so dispose of contest already. See, I'll read it once more from the beginning. It's then miscellaneous case number so petition so under section 5 of limitation for the next person some days under file in application other order and rule 13 for setting aside an ex parte judgment order that so to allow plaintiff to contest this one. I have perused the content. Next para judgment referred to. The aforesaid operative part of the judgment makes it abundantly clear that a counterclaim has been decreed against the plaintiff on contest. The plaintiff could have taken court recourse to order 9 rule 33 only if the counterclaim had been decided ex parte against the plaintiff. Situation thus, the petition of condonation of delay is also dismissed. Now, here can we see whether this is the first threshold the condonation and then the appeal. When in the threshold itself the petition is dismissed, it is automatically dismissed. It is a part of the order of the appeal. Appeal is not found to be maintainable. Court has held it. Court has said that this is not an ex parte. This was an interpretive order, bipartite order. Therefore, order 913 is not maintainable. And so, condonation petition is also not maintainable. That's the problem of the home order. And apex court's decision is, recent decision is claimed by the whole issue. Nothing is there are issues. I acknowledge the juniors to find out of public court also. There are earlier so many reasons are there. So, in that matter, let him pursue the appeal. It will take care of everything. He can argue all the points there. That's my resolution. Petition is liable to be dismissed as the threshold.
Well, one submission just your lordship permit me.
Yes.
Last page of the petition lordship may kindly available. This is the order which I have to challenge before the appellate court. In the order 930 petition, this is the 2-line order passed. Last page of my petition.
Yes.
Records put up in view of dismissal of J case number 264 of 2019 under section 5 of the Limitation Act. Instant J case is dismissed and disposed of accordingly. This is the order I'll have to challenge before the appellate court, my lord. Difficulty is, my lord, I go to the appellate court, court holds that it is not maintainable. This not maintainability issue should have been decided in the appeal. Then I would have argued before the appellate court that see, learned court was wrong in holding that it is not appealable because it is an ex parte decree, and they would have argued that no, it is a matter on contest, it's a decree on contest. Then it's all right. This is the order I have to challenge in the appeal. I cannot challenge that section 5 order, detailed order in the appeal. So in the appeal, my only challenge is this order which says that it is disposed of because of the dismissal of that. Now, as against the order passed in section 5, I have got no appeal lies. Court will say, I will not hear you against any order passed in the appellate court, my lord. Court may say that I will not hear you on any submission made about the rejection of the application under section 5 because no appeal lies under rejection of section 5 here. Petition, my lord. That is my difficulty, my lord. It's not that, my lord, deliberately we want to come here, we want to go there.
No. We are not saying that you are deliberately filing.
My lord, that is why I said, in fact, we discussed, my lord. According to us, my lord, supposing we go to the appellate court will say that you only say that kindly make your submission that this order is bad. This order of 2 lines, which says that I am dismissing because I have dismissed section 5 petition. Now, if I go to challenge the order passed under section 5 of the Limitation Act, the appellate court may say that as against the rejection of section 5 petition, I will not hear you anything because no appeal lies against that. This is the confusion for which we have filed both, and your lordship will pass some order so that entire thing is open before the appellate court. So that the appellate court doesn't say that I will not hear you on the grounds on which may be legal, may be illegal. The application under section 5 of the limitation was rejected. because
Okay.
no appeal lies against that.
Okay, we will say, if we can make any such observation in the,
Yes,
in the order.
yes.
We'll
Then
see.
in that case, my lord, so that my appeal when it is heard, it is heard on merit so that I can argue in everything, and I am not remedialess, my lord. That is
Okay.
my only apprehension.
Okay, now we are dismissing this petition.
Apprehension express is unfounded. How could it be said that the court will not consider all?
No, we will simply observe
Yes.
that by dismissing this application, no, although we are dismissing this petition as not maintainable, yet the petitioner may
Argue on this point.
argue on this point before the
Yes, yes.
appellate court.
Yes,
Only that observation.
You can argue on these points. As I find, apex court has also said that when as I submitted, when the limitation petition is dismissed, consequently, the appeal dismissed or the petition dismissed. Therefore, it merges with. Now, when the question comes that my application has been dismissed by this one line, what is the reason? My condonation petition is rejected. Right. That's the question. Appellate court may itself consider it or
No,
can remand it again.
there is a decision of Supreme Court on this point also.
My lord, what my learned friend is submitting, I'm clarifying with this. The judgment of 2005, Shyam Sundar judgment. Your lordship is aware of that. That's Shyam Sundar judgment of 2005 1 SCC. In that case, what happened? In a appeal, first appeal, there was an application for condonation of delay. That was rejected. Against that, Supreme Court says that since delay condonation petition was rejected, against that, second appeal will lie, no revision. Because by rejecting an application under Section 5, ultimately court passes a decree.
Yes.
But here it is different. Court is not passing any decree. Court is dismissing my application under Section 5. And then as not maintainable. If the court, that's what I'm saying, my lord. If the court simply says, I am rejecting your application under Section 5 and nothing else, and going into the merit of the case. My lord, lordship will I'm just, lordship will give me just 2 minutes, my lord. I'll just clarify one thing. What has happened, my lord?
Mr. Mozumdar, you say there is a decision of Supreme Court on this point.
My lord.
That in that petition, he or she also, the appellate court also considered the merit of the other matter.
Merit of the?
That petition also.
My lord.
13. Order 9 rule 13 petition.
My lord. If this is rejected for condonation of delay also,
yes,
that will be not. My lord, there is no difficulty. If the court, that's what I'm saying, there is one small difference, Lord, you kindly appreciate. If the court goes into merit of the Section 5 petition and finds that I have not been able to explain sufficiently the delay, I am dismissing your application under Section 5 because you have not been able to explain the delay. It is rejected. Then court goes to the appellate court, Section Order 930 petition, and then says, since I have rejected your application under Section 5, I am not entertaining it. Against that, naturally, my lord, I will have to go in appeal. Here, Section 5 petition was not taken up on merit. While taking up the application under Section 5, court actually decides Order 9-13. And then the court says that since, according to me, the Order 9-13 petition itself is not maintainable, I am rejecting your application under Section 5. So my explanation I have given in condoning the delay has not been considered on merit, but it is rejected. Whether this rejection of my Order 9-13 petition on this ground is valid or not, that is what your lordship will kindly examine.
Okay. Next matter.
Well.
Made to the lordship. In this case, I am coming against the order of the first appellate court. That is filed. The appeal was filed against an order 21 Rule 99 and 101. So accordingly, since against the order 21 Rule 99 appeal lies, against that order, that appeal was rejected. I am against that order. Here, lordship, what happens by executing a decree some separate plot of land was position was taken over a separate plot of land of the.
So you filed this appeal under section 100,
Yes, Lord.
second appeal.
Second appeal.
Where is this suggested substantial question of law?
So it is at page number 8 of my memo of appeal.
No, it is not part of the memo of appeal.
It is at page number 8, Lord.
Maybe.
Yes. After the ground.
Your memo of appeal ends after the certificate.
Yes, after the certificate.
So you have to mention it in the body of the memo of appeal.
I have made separate grounds, but this is.
You have to incorporate, there is a decision of Supreme Court also.
Okay.
And in subsection 3 to section 100, it is mentioned. CPC.
Yes, sir. May I read section 100? Save as otherwise expressly provided in the body of the code or by any other law for the time being in force, and appeal lie to the High Court from every decree passed in the appeal by any court subordinate to the High Court if the High Court is satisfied that the case involves a substantial question of law. An appeal may lie under this section from an appellate decree passed ex parte.
Subsection 3.
In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Yes, Lord.
You file amended memo of appeal.
Okay, Lord.
Incorporating the suggested substantial question of law. Heard, Mr. R. Sharma, learned counsel for the appellant. Leaves the matter after 1 week.
Yes, Lord.
In the meantime, Mr. Sharma shall file amended memo of appeal incorporating the suggested substantial question of law in the memo of appeal. In view of the provision of subsection 3 to section 100 CPC, list the matter on fixed.
May I Lordship? May I Lordship, please?
Yes.
So the short matter, my lord, if Lordship agrees, my lord, we can dispose it in the motion stage itself. I mean, just a background, my lord, in the 2 minutes. This petitioner, my lord, is a lecturer in a college. Now, my lord, he has a certificate of scheduled caste. He is subcaste, the certificate says Patni. Now, in fact, my lord, he belongs to a subcaste of Mali. That was the dispute. Then the scheduled caste governing body take up the matter, holding press conference against the petitioner, etc., etc. Then we file this suit, my lord, before the Charaido court for compensation and damage, my lord. In that, while the suit is pending, my lord, the defendant number 1 again issued a letter. And saying that in the title suit you have said that you are a Patni and not Mali, so please surrender your certificate. Now, while the suit is pending, my lord, that letter itself is tried to intrude in the adjudication of the suit, my lord. And thereafter, under such circumstances, we have filed an application under section 151, my lord. Only simple prayer, please ask the defendant not to do it. Now, the court by the impugn order, Lordship will kindly look at the impugn order. Lordship will kindly have a look at page 85, my lord. Second paragraph. First paragraph is regular petition, my lord. Second paragraph relates to our application. May I read? Also, seen the petition number 164 of 2026, filed by the plaintiff under section 151 CPC, wherein it is stated that a defendant has, during pendency of the suit, served a notice to the plaintiff dated 27/4/26 for surrendering his caste certificate, which is an abuse of the power of the defendant. And if the defendant are not restrained from passing such notice or drawing any proceeding against the plaintiff shall be highly prejudiced. Heard both sides, the learned counsel for the plaintiff has argued such and such, my lord. We may skip it. Page 86, my lord, is a finding. Last paragraph. It appears, Mary, It appears from the record that the present suit has been instituted by the plaintiff seeking compensation on account of Ali's defamation. The notice dated 27/4/26, which is from the basis of the present petition, is a communication admittedly addressed by the defendants to the plaintiff personally. This is not a personal letter. He is issued the letter in the capacity of a chairman of the development, the caste development board. At this stage, whether the contents of the said notice are defamatory in nature, I am not saying it is defamatory, my lord. Not in a matter of adjudication upon during the trial on the basis of evidence to be led by the parties. Further, this court is the considered view that no blanket order, we are not asking for any blanket order, can be passed restraining a party from issuing notice or initiating legal proceeding. As such, restraint may amount to curtailing the legal remedies otherwise available to the litigant under law. Mere apprehension of prejudice would establish a mean and abuse of the process of the court. Irreparable injury is not sufficient, such and such. So therefore, my application was rejected. I am simply saying that the lease is pending. So the principal doctrine of the lease pendency may not applicable. So while you had contested the suit, the defendant number appeared, filed WS, my lord. 2 and 3 also filed WS. Now, while the suit is pending, how could you say that I am to surrender the caste certificate, etc., etc.? And lordship is aware that in a judgment of the Honorable Supreme Court 94 says that the local body has no jurisdiction to adjudicate the caste certificate. It is the state scrutiny committee will decide. All those are subject matter of the suit, my lord. My only prayer, my lord, before this honorable court, that the London trial court may reheard the issues, my lord, and decide afresh. Because the doctrine of lease pendency is applicable in this case, and which we addressed before the court, but court did not enter into, and saying that I cannot pass any blanket order. I am not asking for, my lord, of any blanket order. My only prayer before the court, that let the defendant may restrain themselves from doing anything which is subject matter of the suit. That's my simple prayer before the court.
Okay, we'll see and pass forward.
My lord, my lord. That's only my prayer, my lord. My lord may dispose this matter. I may just refresh the afresh hearing, my lord, and pass it.
Pardon?
Again,
Not necessary, not necessary. We'll dispose of the matter.
No, I'm not. I'm requesting this court. My only prayer is that directing the learned trial court, my lord, lordship may to hard afresh and pass an appropriate order.
We'll see.
My lord.